Good morning, everybody. Happy Thursday. Welcome to the Courtroom Files Live. It's nice to have all of you here today. Let's start our day in Michigan with Judge Dad.
6-3.
He wasn't in the office or not.
Your name?
Brad, no.
All right, you have a dog running at large case. That's a misdemeanor. And you have failures to pay on 2 civil infractions, $213. If I find you didn't pay and could have paid, failure to pay was not allowed your fault, you could be incarcerated. You could get 22 days on each of these. Do you understand that?
Yeah.
On the dog at large, you could get incarcerated. You could be incarcerated. I'm just telling you the maximums.
Okay.
Up to 500 fines, 90 days jail, costs are all those. You understand that?
Yeah.
Did you get an advice of rights form today?
He was unable to read it, Your Honor.
Okay, you're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You're presumed innocent. You have the right to a lawyer. I'll be happy to give you a lawyer right now. Would you like a lawyer?
I don't think so.
All right, you have the right to a trial by court or jury at a trial. You have the right to remain silent, right to testify if you so choose, right to a jury trial, right to bring in your own witnesses, right to use the subpoena powers of the court to bring in those witnesses, right to testify, as I said, or remain silent. If you remain silent, that silence would not be held against you. If you plead guilty, you're waiving all those rights. You're waiving the presumption of innocence. You're waiving the requirement that they prove you guilty beyond a reasonable doubt. Do you understand all that?
Yeah.
You still wish to waive your right to a lawyer?
Yeah.
I'll enter a not guilty plea. Do you, what kind of dog is that?
So, Reese Mountain,
Do you live in a, Lafleur, that's a house, right?
yes.
Do you own the house?
Yes.
All right, $500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. You're to keep the dog in a fenced-in yard, in your house, or on a leash. Do you understand that?
Yeah.
I'm entering not guilty pleas for you on these noxious weed charges. This is for failure to pay on both of these.
Okay.
You owe $213 on each. Do you understand that?
Yeah. Can you remind me about these weed things?
I mean, all I can tell you is duty to cut, destroy, and remove grass and weeds, it says on one on May 14th of 24, and on the other one, weeds in front yard in excess of 12 inches, measured at nearly 24 inches tall, unsightly weeds in backyard, not measured, photographed, and uploaded to LensLock, issued on May 14, 24.
Yeah, I didn't know about those. But I guess you put not guilty, so.
Well, I'm entering a not guilty on failure to pay. You've already been found responsible. You didn't show up in a default judgment.
Because I didn't know about it.
I mean, you can fill out a motion, but he says he served a copy on you on May 14 of 24 on the one, and on July 15 of 24 on the other one. The officer did. So you owe $416 on those two, and we have this misdemeanor. I'm sending you over to Rockwood prosecutor to talk to him about both of those. Okay?
All right.
And then you'll come back in front of me either way. Any questions?
No.
All right, best of luck. Kevin Shane Tishkoff, 25F244076. Good morning, Mr. Osmond.
Morning, Your Honor. Jeff Osmond on behalf of Kevin Tishkoff.
All right. What in the world was he doing?
A moment of stupidity.
Wheelies on motorcycle. These guys driving those motorcycles, I see them driving up north and back, and I'm telling you.
I know. No,
I
I
had a
talked.
guy, right? Where was I? Let me think. Yeah, I was driving on 4th Street to work a 3 days ago, I guess. I think it was Monday. Somebody decided he was going to pass the car that he was following in the left lane by driving in between that car and my car that was in the right lane. I mean, and he wasn't going slow, and I'm thinking, geez, you're taking your life in your own hands. Anyway, you worked with the prosecutor. This will be a plea to impeding the careless to be dismissed. True?
Yes, Your Honor.
He's recommending fines and costs of $350. You guys agreed on?
Yes, sir.
Charge impeding traffic responsible or not responsible?
Responsible.
All right, I'll accept the plea. $350. I'll give him till July 3rd. Is that going to be enough time?
That should be fine. Thank you very much.
Have a great day. Thanks a lot. Jenkins, Martiano, Rashawn Jenkins, 25F2441588 A and B. Stephen Singleton, can I have a seat up at the table here? Your name?
Martiano Jenkins.
You're charged with unlicensed, driving while unlicensed and disobey a stop sign or a traffic signal, rather. You have the right to a lawyer on these. If you want one, I'll give you one. Do you want a lawyer?
No, Your Honor.
It is alleged that on June 8 of 25 at 3:43 p.m. that you were operating a motor vehicle on Breland or Hall and Flat Rock. They think you were unlicensed or driving without a cycle endorsement. That is a misdemeanor punishable by up to 500 fines, 90 days jail costs, or all those. Do you understand that?
Yes, Your Honor.
You also have a civil infraction charge, disobey a traffic control device. That's a 3-point civil infraction. Do you understand that?
Yes, Your Honor.
Did you sign the advice of rights and read and understand the rights?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes, Your Honor.
All right, you still wish to waive your right to a lawyer?
Yes.
I'm entering a not guilty plea, $500 personal bond. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. We're going to take this file over to the prosecutor. You go talk to him. Either way, you're coming back in front of me today.
Okay.
Do you understand that?
Yes, Your Honor.
All right, any questions?
No, Your Honor.
Thanks.
Thank you.
Singleton, Stephen Singleton, 25W837520. Your name, sir?
Steve Singleton.
Mr. Singleton, 377. This is a show cause. Do you have all that money to pay?
No, I've been making payments, Your Honor. I had you sitting on a $50 payment per month.
No. Oh, okay, beginning March 7th?
Yeah, March 7th, yeah, so I understand this. I've been making my payments.
Well, I told you to pay $40 on February 19th, right?
Mm-hmm.
And then I told you 50 a month starting March 7th,
Mm-hmm.
right?
Yes, that's correct.
And you didn't pay anything until June 6th, right?
Right, that's correct. I gave her $100 on June 6th.
Well, that wouldn't be enough. You owed for March, you owed for April, you owed for May, and you owed for June.
Oh, okay, okay.
So you're $100 light.
Yes, yes.
You went in March, April, May and didn't pay anything.
Oh, okay.
Remember when I told you to come talk to me if you had a problem?
Yes.
Why didn't you do that?
I can get back on that payment program. That was not.
Listen, Mr. Singleton,
Yes.
we're easy to deal with here. I'd like to think we're easy to deal with here.
I know.
But the staff has they have better things to do than issue show causes and chase people around. So when I told you you needed to come talk to me, I still don't understand why you didn't come talk to me when you skipped 3 months worth of payments. Why'd you do that?
Oh,
Well, I don't either. Do you work?
no, I get on Social Security disability.
Okay. All right. All right, I'm gonna do this for you. I'm gonna dismiss the show cause. You pay 50 per month.
Okay.
I'm gonna start this beginning July the 7th.
The 7th.
Is that early?
July 7th.
July 7th.
You make it August the 2nd.
You don't wanna pay in July either?
Well, I'm gonna try to give you some of this, if I tell you that, I'm gonna try to give you something, I don't get you nothing, then I will be back in the same situation. But I know I have something in August.
I'll set it August 7th
Okay, thank you, that's fine.
and the 7th of every month.
September,
What are you gonna do if you don't have the money on August
I'll
7th?
come see you.
Or September 7th?
I'll come see you.
Or October 7th?
Come see you.
Good enough. I'll dismiss the show cause, Lisa. Set them back up on the payment plan. 50 per month beginning August 7th, okay?
Uh-huh.
Good luck.
Thank you.
Just come talk to me next time.
I will, sir. Have a good day.
You too. Brittany, Rochelle, Chapala Tweed.
Good
Your
morning,
name?
Your Honor. Yes. Yes, sir.
Good morning.
Good morning.
Your name?
Brittany Chapala. The big, long, funky one.
The big long what?
Big, long, funky one.
Funky name?
Yeah.
So it's Brittany
Brittany
Rochelle Chapala Tweed. That's a nice name.
Oh, thank you.
All right, so you have a drive while license expired.
Yes.
And you also, that's the only case you have. I'll be happy to give you a lawyer right now. Would you like a lawyer?
So here's, can I say Your Honor? So I had a really good experience. I did have you guys look before.
You were in court before?
Yeah, I was. I had a really good experience with you. Maybe I'm not supposed to say that, but you guys, the interaction I had with the officer and everything was good. Where I'm at right now, I'm like, I don't like to say it, but the officer pulled me over, gave me an expired, what is it, license?
Right.
And, he did give me grace on that. So if I plead,
You have a new license now?
uh,
Did you get your license renewed?
yeah, I did. My trans was going on my other car, or on my car.
All right, just
And so
hang on a second. Let me tell you what you can do. I can either give you a lawyer, or I can go ahead and arraign you on this charge and let you go talk to the prosecutor. He's gonna be reasonable with you.
Yeah, because I don't wanna, combat against anything, officer. Like I said, it was really good interaction and all that. He cut me a big break.
Why'd he cut you a big break? Let me see.
Well, I would say so because. when I-
Defective equipment, no insurance, you gotta have insurance.
Yeah. Well, that's the thing, that's where I was getting at when I kind of fumbled over my words, it's a little hard for me to talk about. So I had you guys before since my accident happened, and last time you guys gave me grace as well. I really appreciate that because I have percussion disc and I'm a hairline away from being paralyzed from my neck down
Oh, no.
at 33, yeah. So, it's just I'm trying to take a cheaper revenue, but as soon as I get everything good.
Let me arraign you.
Listen.
Let me arraign you. And then you go talk to the prosecutor. Is that okay?
Yeah, and I didn't know that before.
Why?
Yes.
This is not the end of the world. This is an
Yeah.
expired license. Nobody thinks you murdered anybody. Just
I know, I
relax.
appreciate that. And I don't want to be pulled over, but I had to tell people out. But I'm gonna be honest, I still have to communicate my kids, so hopefully, I don't see you again, but, I still have an obligation because I'm so I still gotta make this, things like that.
But you got a valid license now, right?
Yes.
Do you have insurance?
No, my car is actually down.
How'd you get here today?
I got, dropped off across the street.
Why'd they drop you off across the street? You didn't drive here, did you? You didn't drive here. I know you wouldn't have driven here if you didn't have insurance. Listen, let's not make this worse. I'm gonna go ahead and arraign you.
Whatever thinks best.
If you want a lawyer, I'll give you a lawyer. If you don't, I'm gonna go ahead and arraign you and I'm gonna send you to the prosecutor.
Because if it's easier to plead guilty.
No. Let me just arraign you. I'll send you the prosecutor. He's a reasonable person. He'll be fair with you, okay? So they think on June 10th of 25 that you had an expired license while you're operating a motor vehicle in Flat Rock on Telegraph near Gibraltar. That is a misdemeanor. It's punishable by up to 100 fines, 90 days jail, costs are all those in 2 points. Do you understand that?
Yes, sir.
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights. There will not be a trial done. Do you understand that?
Yes.
Okay. If you still wish to waive your right to a lawyer, tell me. I'll enter a not guilty plea and I'll let you go talk to Mr. Cayley. Is that what you want to do?
Yeah.
Okay. Where do you work at, ma'am?
I don't work, I'm trying to get my social security book because I need to keep telling me I'm okay. So
What do you mean,
I've
Social
gotten
Security?
denied I've gotten denied a couple of times, but,
Are you married?
I have three kids, but my kids are older.
How old are they?
11, 12, and she's about to be.
Okay, not over
And then
18.
So they're not over you.
Are you collecting child support?
I get like $25 a month, so they don't really consider it.
$25 a month. Was it the same father of all three children?
My girls have the same dad, but my son's dad, yeah, it's just him. But, so they're separate.
Do these guys not work?
So I have joint custody with my son's dad. I'll tell you what, you know, when you're young and you have kids, you don't think about how important it is. Like, we have kids, we don't really think that far in the future, you know, and that's just life. And then my girl's dad is never, I think he lives like 10 minutes down the street.
He's gonna regret that someday. You go talk to
So it's all
Mr.
me. I'm trying to do what I can.
All right, just relax. You go talk to Mr. Cayley here.
All right, I'm gonna.
Roger, take this file. This young lady has 3 kids, deadbeat fathers. They're not around. One's paying $25 a month. She doesn't work. She's almost.
And I know everyone has.
Go talk to him. Relax. Take a deep breath. Go talk to Mr. Cayley. He's very fair.
Well, thank you guys for always being fair, though. I appreciate it.
All right, just keep smiling. Life will get better if you just take one day at a time.
Thank you.
Good luck.
Thank you.
And you're coming back in front of me either way, okay?
Okay, sounds good.
Jason Henry.
Good advice given at the end of a hearing that took way longer than it needed to. Good morning, everybody. Welcome again to the Courtroom Files Live. Happy Thursday. I'm in a good mood today. I hope all of you are as well. Let's go to Florida. Judge Wade Mercer, first appearances for Jackson County.
Probation possible warrant. That warrant has been signed by the circuit judge, Judge Garcia, and there's a no bond warrant that she has signed. So, Mr. Swindell, what I'm going to do this morning is get you arraigned on this no bond case and get you an attorney appointed if you're asking for one, and then we're going to see if anybody has anything else. Mr. Swindell, you want an attorney appointed to represent you in the VOP?
Yes.
I'm going to appoint the public defender's office to represent you in the violation of probation charge. Listen to Mr. Blunt, and then we'll see if you have any questions in just a moment.
Your Honor, we acknowledge receipt of the affidavit of violation, waive formal reading, enter denials to that allegation, and I would ask that Mr. Swindell be set for the next VOP court date. I think it's July 10th, Your Honor.
I have July 10th on my cheat sheet here, Mr. Mitchell.
No objection to the violation of probation.
So, Mr. Swindell, we're going to schedule you for July 10th. You'll see Judge Garcia, and the attorney that does VOP cases, Mr. Guy Green. He's the assistant public defender that handles those cases. He'll come see you at the jail before then. Mr. Mitchell, anything else?
Your Honor, I did receive information today regarding his new law violation on the DV battery that we believe that he has violated the conditions of his of his bond by having contact with the victim through jail calls and possibly jail visits there. We were told that, yes, the victim created an account in an attempt to contact Mr. Swindell, but Mr. Swindell was told here in court of his conditions, no contact with the victim, and even with that, he still reciprocated the conversation when he shouldn't have.
I understand how someone can set up a fake telephone name or whatever, but how could she do a visit at the jail?
That part I don't know. I don't know how it regards the visits.
Okay. So, Corporal, all I can do in this case is ask the jail to look into that. Please review his telephone calls. If there's evidence he has had contact with the alleged victim in the battery case, either in person or inappropriately over telephone contact, I need to know that, and we'll get him back in court next week. But, Mr. Swindell, you've heard everything I've heard, sir. If there's evidence that you've contacted her or had contact with her, even if she initiated the contact, what I usually going to do, I'm going to stop your telephone visits totally, to stop them, have no visits other than with your attorney. And the second thing I'm going to do is I'm going to revoke any bond I had set in that case and set it at no bond. So I'm instructing you again, no contact with the alleged victim means no contact at all. If she contacts you, don't talk to her. You cannot talk with her about this case. Mr. Swindell, don't talk about the allegations that Mr. Mitchell's received. But I do want to ask you, do you have any questions or anything about that that's unclear?
No, sir.
In the courtroom, ladies, any questions? So he's got no bond in the violation of probation. He's still got a bond in the battery case, but there's no point in posting it because he wouldn't get out because of the VOP. I want him to know who's here. You're his mother, correct? I want you to know your mother is here on your behalf, Mr. Swindell. Just be aware of that. All right. So, Corporal, just let me know first of the week, if y'all will. I'll be out tomorrow, but let me know the first of the week, as well as Mr. Blunt's office and Mr. Mitchell's office if there's evidence of telephone contact that violates a court order, please.
Yes, Your Honor.
Mr. Wendell, have a good day.
Yes, sir.
Thank you for coming, ladies. Trey Ferguson is next.
Yes, sir. Good morning.
Good morning, Mr. Ferguson. I believe I held you originally to see what Gaston County was going to do. I do have an order revoking bond from Gaston County signed by Judge Fleury over there. So what that means is just be aware, you have the right to post bond here. If you post bond, you'll go to Gaston County to deal with the allegations against you over there. The judge has revoked your bond in Gaston County. Mr. Ferguson, do you have any questions?
May I have a bond reduction, sir?
No.
Please, sir.
No.
So what is my bond, sir?
Your bond was set at $5,000 cash or surety, which is the typical bond for someone who's already out on bond somewhere else. So you've got a $5,000 bond here. That's a reasonable bond, and considering that you're already out on bond somewhere else, I'm not going to lower it any further.
Yes, sir. How long do I have to stay in here? How long would I have to stay in here before I come back to court or before I go there? How long would I have to stay here? Because I'm not pleading guilty to this and I'm not pleading guilty to that. So how long would I have to stay in court? How long would I have to stay in jail?
Your next court date will be the arraignment docket for July, which will be July the
9th, I think. He'll be on the jail.
July the 9th will be your next court date. If you ask for a lawyer appointed to represent you on that date.
Yes, sir. I'm just saying, how long?
I can't answer that question because you haven't even been appointed a lawyer yet in the case. As soon as you get a lawyer appointed, the lawyer will talk to you about the trial, then we'll set it for trial. So July 9th is when we would set it for trial, and you'll get a trial date. The trial date would either be in July or August, depending on what happens once you talk with an attorney. As far as Gaston County, I have no idea about Gaston County. They just say, we want him. We're going to revoke his bond over here. Any other questions?
So I just sit here and wait on, what do I do now, sir?
Well, you can post bond. If you post bond, you'll go to Gaston County. If you can't post bond, then you got charges pending in 2 counties, so you'll be right where you're at until your next court date.
Okay, because I can't post bond, sir, and I'm not pleading guilty, sir.
You don't have to. That's what a jury's for. Have a good day, sir.
Yes, sir. Thank you.
Next case is Charles Holly.
I did relay that offer to him again, and he's adamant.
Simple. Mr. Holly, good morning. Mr. Holly, you're here because you were held for a possible violation of probation warrant out of Bay County after your arrest in Jackson County. The Bay County judge has signed a VOP warrant, and it does have no bond. Mr. Holly, what that means is just similar situation to Mr. Ferguson. You've got a bond here, but if you post it, you simply go to the other jail because they do want you over there for violation of probation. That's what you're accused of. And you got your battery case here that's coming up on an upcoming court date. Any questions, sir?
So are they coming to get me, or am I going to take care of this first?
You'll take care of this first, unless there's a transport order, which are very rare. Once in a blue moon, I'll see a transport order, but they're very rare. In all likelihood, you'll resolve this case first.
Yes, sir. When's my court date on this case, if you don't mind?
July 9th. July 9th is a jail arraignment docket.
Okay.
Have a good day, sir. Curtis Adams.
Good morning, Your Honor.
Good morning, Mr. Adams. I believe that you resolved a local new misdemeanor or criminal traffic charge, and it looks like there's a violation of probation affidavit filed. There's not a warrant filed because it was a warrantless arrest at the time of the original arrest. So you've got no bond. I'm setting you no bond in the VOP. I don't think that's a surprise to you. We're going to go ahead and get you arraigned and get you a lawyer appointed if that's what you're asking for, so we can keep your VOP case moving. Would you like to have an attorney appointed to represent you in the VOP case, sir?
Yes, sir.
I'm going to appoint the Public Defender's Office of the 14th Circuit to represent you. Listen to Mr. Blunt, please.
Your Honor, at this time, we'd enter denial on behalf of Mr. Adams, waive formal reading, and set him for the July 10th court date.
July 10th, Mr. Mitchell, anything?
No, Your Honor.
So July 10th will be your court date. Mr. Adams and Mr. Green will come see you at the jail before the court date. Any questions?
No, sir.
Thank you. Have a good day.
Have a good day, sir.
You too. Joshua Hall is next. Hall, good morning. Mr. Hall, you've been accused. Good morning. You've been accused of 20 counts of possession of child pornography and 1 count of unlawful use of a two-way communication device. Mr. Hall, each of these charges is a third-degree felony. So you have a total of 21 third-degree felonies that you're accused of. Mr. Hall, I'm going to appoint the public defender's office to represent you for first appearance purposes. And I'm going to ask that you listen to the attorneys. We'll see if they have any additional information on your behalf. Mr. Blunt, anything?
Your Honor, at the time of his arrest, Mr. Hall was gainfully employed. He's been a resident of Jackson County, specifically Marietta, for the past 20 years. And we would just ask the court to take that in consideration, that he has ties to the community, is or was employed at the time of the arrest, and is not a flight risk.
Thank you. Mr. Mitchell, anything?
Also, I believe he doesn't have a record that I could see.
I don't see any criminal history before this. Mr. Mitchell, anything?
Your Honor, we just request that the court take into account that these 20 counts are all enhanced to a second degree as stated out in the complaint pursuant to statute 775.0847, specifically 2B.
You know what? He, on the front page of the complaint, he has the statute number for third degree. But in another portion, it does say reclassified, because I did look at that statute this morning because I knew there was a reclassification statute if you have over a certain number. So let me go look at that statute. 7750847. I think that's a typo.
No, that's the right one.
775-0847. It's not a Florida statute.
Not the dash, but period.
Florida statutes don't have dashes. Yeah, I think that's
that portion is a typo.
775.08.47 is probably what they meant. Let's see what it says. Is each one reclassified, or is it one new charge? That's a second degree felony.
Apparently each is reclassified because, as he states, I think it's specifically 2B5, any motion picture, film, video involving a child, regardless of length and regardless of whether the motion picture, film, video, or computer generated motion picture contains sound, qualifies for it to be reclassified to the next highest degree.
You're getting 2B5 just out of your reading, because he doesn't give a subsection. The officer doesn't tell us what subsection he's talking about on this statute. So 2B5.
Could also be 2B3 also.
Yeah, who knows? It'd be a lot easier if they just tell us what subsection. Let's see. Some of them could be 2B3, but they didn't describe all of them.
Or even 2A.
No, there's no evidence of someone, or maybe. So the cutoff is 10, and it looks like it classifies each crime to a second degree felony. Okay, so that's what he's accused of, and it does have that statute number on the complaint. It's just it's a typo there, but it's got the right numbers. It just has a dash instead of a decimal point. Mr. Blunt, anything else?
No, sir.
All right, so Mr. Hall, I'm going to set your bond at $5,000 on each of these counts. You have 21 counts. That means your total bond is going to be $105,000 cash or surety. Mr. Hall, your bond also will have a condition that you not have any internet access. Well, if you have your job, I'm not trying to make you lose your job. I have no idea if you're going to still have a job. That you not have your internet access outside of work. So if you have to have internet for work purposes, that's okay during your work shift hours. But outside of work, you can't have any internet access because of the type of allegations that are facing you, that you're facing. But your total bond is $105,000 cash or surety. Cash or surety means that you can go through a bondsman, sir, and you have the right to use the phone at your first appearance to try to post the bond. I did read the complaint a couple of times. There's evidence of other personal items in that same Dropbox. Frankly, I don't know what a Dropbox is, but I've got some idea, I guess. But I was a little concerned about the probable cause aspect until I saw all the things that are there, including a very recent tax return, which would imply that, at least arguably, there's evidence that he's the only one that had access to the Dropbox, according to the complaint, and that to have a 2024 tax return that's had to been filed within the last 5 months or so. So what's not in there is when the last time the drop box was accessed, which would be helpful, but the officer may not have had that information at the time they did the complaint. So that's your bond, sir. You have the right to post bond. And if you do, you'll be released. If you're not able to post bond, you'll be seen on an upcoming court date. Do you have any questions, Mr. Hall?
No, sir.
I think our clerk has a question. Yes, ma'am. Yeah, not outside of work. Well, just no internet access outside of work duty. Work. He can have the internet access while he is at work for work purposes only. That's probably the best way to put it. So if he still has a job, then, you know, I don't want the internet to keep him from having a job, but I don't want him using the internet outside of work. You write all that? All right. Wish you the best, sir.
All right, sir.
We have.
All right, the crowd has spoken. We'll go to Judge Simpson. I'm guessing you guys want to wait for Glazer until we get a little closer to lunchtime, but maybe I'm wrong. Let's go say good morning to Judge Simpson.
Mr. Pfeiffer, can you state your name, please? Oh, there, I got it.
Yes, sir. Ryan Pieper.
Sure, okay. Thank you. All right, what are we doing today?
So has the court received the evaluation from the forensics?
I have, it is dated June 18th, that one.
Yeah, so we sent an order finding him competent. We have nothing further to present. We would like to set it for probable cause conflict.
Anything from the people? All right. Court, based upon the people of that report, would find that defendant is competent to stand trial. Specifically that the defendant can understand the nature and objects of the proceedings against him and can understand and can rationally his defense. Report the defendant is deemed competent. Like to set for a probable cause conference?
Yes.
Yes.
Yes, Your Honor.
All right. You want 2 weeks out? Will that be enough time for you?
Yes, 2 weeks should be fine.
Probable cause conference will be set July 10th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Bond will continue.
Thank you.
Court does call the case People versus Brian Brown.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Oh, good morning. We do not have Mr. Perkins. Counsel, have you heard from Mr. Perkins at all or his office?
No, Your Honor.
Mr. Brown is not here, is that right?
Mr. Brown is in Bay County.
Pardon? Oh, there he is. Mr. Brown, can you state your name?
Brian Brown.
All right. Your attorney has not signed on. Was he coming by Zoom or in person? Pardon?
I do.
All right. Contact his office. I'm going to pass this matter briefly, sir, okay? Try to get your attorney here. Court does call the case of the People versus Christopher Nunley.
Student Attorney Kara Rosengren requesting permission to practice under Michigan Court Rule 8.120 on behalf of Attorney Hannah Apple under the supervision of First Assistant PD Michael Gotti.
Permission to practice is granted. Sir, can you state your name, please?
Christopher Nunley.
All right, what are we doing on this?
Thank you, Your Honor. We're requesting to adjourn as Attorney Apple has a meeting scheduled in person in Jackson on 7/25 at 2:30 p.m. with Mr. Nunley. So we're going
7/25?
Yes, July 25th.
She couldn't get one before that's a month out.
Yes, Your Honor. From my understanding, they only allow in-person visits in Jackson on Fridays, Saturdays, Sundays, and Mondays, and only in the afternoon.
A lot of those between now and then.
That was the first available that she could get, Your Honor.
July 31st, 2025, 9 a.m.
Okay, thank you, Your Honor.
Court does call the case of the People versus Anthony Lafredo.
Assistant Public Defender Natalie Pate with it on behalf of Mr. Lafredo, who is present via Zoom from the Jackson County Jail. Sir, can you please unmute and state your name for the court?
Anthony Lafredo.
Thank you, sir.
Thank you, Your Honor. I have a video visit scheduled with Mr. Lafredo tomorrow morning at 10 a.m. There is an.
So it's not a month out?
No, Your Honor.
Oh, okay, go ahead.
I finally got approved, but it's scheduled for tomorrow morning. And there is an offer in this matter that I wish to convey to my client. So I would ask for a brief adjournment.
All right. Without objection, July 10th, 2025, 9 a.m. Bond continued. All right. Thank you, sir.
Your Honor.
Thank you, sir. We'll talk tomorrow.
All right, thank you.
Court calls the case People versus Anitra Comer.
Amber Children of the Panhandle People.
Sarah Rosengren, under the supervision of First Assistant PD Michael Gotti, on behalf of Ms. Coomer.
Coomer, can you state your name, please?
Anitra Coomer.
Thank you.
Your Honor, we're asking to adjourn as we have an application pending for a visit to the Women's Correctional Facility.
Okay, how soon has it been cleared? I realize there's a problem with these visits, but.
Yeah, I'm sorry. I'm unaware, Your Honor, if it's clear or not. I just know that the application is pending. It has been put in.
July 17th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the cases of the People versus Terrell Green.
Amber Children of the Panhandle People.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Green. Mr. Green, please state your name for the record.
Terrell Green.
Thank you.
We're asking you to set all three cases for preliminary examination, please.
Discovery is complete.
From my understanding, yes, Your Honor.
People have their witnesses available July 8th. Or where is he?
He's in MDC, and with the holiday, I'm a little concerned about our ability to get him.
Any objection?
No, Your Honor. He's in county, but he is incarcerated, so either way.
Is he here? He's here?
No, he's
No.
in Livingston.
Oh, Livingston.
I'm concerned about being able to get a right turnaround.
All right. Understood. Preliminary examination in person will be set July 15th, 2025, 9 a.m. before Judge Moore. Bond will continue.
Thank you.
Court does call the case of the People versus Robert Moyle.
Brian Bowling on behalf of Mr. Moyle, you're. Just state your name on the record, please.
Robert Moyle.
Your Honor, we're here to ask for a examination in this matter today. To my understanding, all discovery is complete.
People have their witnesses available.
We'll do our best, Your Honor.
Preliminary examination in person will be set July 8th, 2025, 9 a.m. before Judge Balvo. As to bound.
Your Honor, it's come to my attention that this defendant has made 6 complete calls to the victim in this case, as well as 16 attempts to call. This time, we asking that this phone please be revoked.
Any response?
Well, Your Honor, I'll just state that that's the first I'm hearing of this. Obviously, I don't know what the substance of those conversations were or that they were actually even placed at this point in time. I'd ask the court to deny that motion.
Defendant's bond will continue in its monetary fashion. However, pending a hearing, if the defendant requests, defendant's phone privileges are hereby revoked.
Thanks, Judge.
Court, you guys got to keep moving. Court calls the case of the People versus Robert Ciotti. Ciotti.
Good morning, Your Honor. Sam Bernstein for Mr. Ciotti. I've been unsuccessful in being able to reach him, so just me today.
Bench warrant will issue for defendant's failure to appear. Bond will be set at $10,000. As surety, that warrant will issue immediately. Court calls case People versus Antonio Williams.
People.
He's in proper.
In the back.
Pardon?
There was a bunch of them ganged up.
All right. Your name, sir?
Oh, Antonio Williams.
All right. Mr. Williams, you're appearing here at a probable cause conference without counsel. I will advise you that you are charged with the offense of assault with intent to do great bodily harm less than murder, felony punishable by up to 10 years incarceration and a $5,000 fine plus court costs. Do you understand that, sir?
Yes, sir.
All right. You understand also, as I've indicated, that you're appearing here without counsel. Let me first ask you, is it your desire to proceed without counsel, or do you
No.
wish to have an attorney?
I wish to have an attorney.
All right. This is a public defender case.
First Assistant Public Defender Michael Gaddy on behalf of Mr. Williams, Your Honor.
All right.
I'd ask the court to adjourn the probable cause conference to allow us to obtain discovery, get officially appointed by the appointing authority, and
I don't think
with
it really does. That doesn't need to be done. But
oh, good. Okay. I don't know how
it's already done.
Oh, great. Okay. Your Honor, I would then ask for an adjournment of the probable cause conference so we can obtain discovery and review it with Mr. Williams.
July 10th, 2025, 9 a.m. Bond continue.
If I could ask the court what the bond is current.
Bond in this matter is currently set at 100,000 cash surety.
Thank you, Judge. We'll come visit.
Court does call the case People versus Andy Rosales.
Ashley Lonnie for the people.
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Rosales. Please state your name.
Andy Rosales.
Your Honor, discovery is complete. We're asking the court to please set this for exam.
People have their witnesses available the 8th.
We'll try, Your Honor.
Preliminary examination will be set in person July 8th, 2025, 9 a.m. That is before Judge Freshour.
Thank you, Your Honor.
Thank you, Your Honor.
Bond will continue.
Let's switch it up. Let's go to Texas, and we will see Judge Stevens.
23 CR 1222 and 23 CR 951. Both the state of Texas versus Jeremy Dixon. Mr. Dixon? Yeah, present with your attorney, Mr. Vasquez, and the state's attorney. All right, the court has reviewed these files and recalls these cases. Go ahead, Mr. Vasquez.
Your Honor, it's a $1 million bond on the murder is the one most concerned with, and we'd asked for the bond to be lowered to $150,000, giving Mr. Dixon a chance to bond out. I've spoken with family members, but none of them are here to testify. I'm hoping they can pool the resources and come up with enough money to sign a contract to give to Mr. Dixon out. They've spoken to some bondmen, and he could get out and work until his trial date, and maybe hire a lawyer of his own choosing.
How would that work? Well, he hadn't hired one yet, right?
No, sir.
Well, he says he has zero income. This was back on October 23 when he was arrested about 2 months after the murder case was filed. And he claimed zero income. That's my writing. I wrote it. Zero income according to the defendant. I was on what's changed.
Your Honor.
Wait a second. What's changed? You know, I mean, he's been in jail. So how can he hire somebody if he has zero income?
Well, Judge, I don't want to misrepresent anything. I'm thinking, or it's been indicated to me that the family members will try and raise him.
What's stopping them from doing that right now?
I don't know.
What else do you want to add? Because I've got some things I'll put on the record.
That's all I have.
Anything from the state?
Just that the nature of these two cases, that the timeline in which they occurred makes it very clear to me that the bond is sufficient and should not be lowered.
Okay, anything you want to say?
Yes, at the time, October 2nd.
Of what year?
23. I was already incarcerated August 6th. I was arrested August 6th when I lost my job because of my arrest.
Okay. Have you been in custody ever since?
Ever since.
Yeah. Okay. So where would your income come from if you were released?
Work.
What work? What work do you have?
Well, my family has a mechanic shop.
Oh, okay. Are you good at it?
Yes, sir.
Okay. Well, how much do you get? How much do you get paid? How long did you work with them?
Well, all my life.
All your life? Oh, okay. And you are right now what? 35. Okay. And you've been working for them. And you've made a good income?
Yes, sir.
Since how long were you working for? Like when you turned 18 or something?
Yeah.
And so about 16 or 17 years? Okay. So how much is it that you made?
I go by commission.
Sir?
You go by commission.
Okay,
50%.
whatever. How much income did you have? Annually about?
Oh, 50,000 a year.
50,000 a year? That's pretty good. I want you to send me all your income tax returns so that I can verify that. And those are on file. Get them to me so I can look at them, okay?
I haven't filed taxes since 2021.
Get the ones you had before. Get all the tax returns that you have filed. You can get those from the IRS, copies of them. You ought to have copies.
Yeah.
Get those so I can verify that you really had an income like that.
Yeah, and I work side jobs too.
That should be on your income tax return.
Yeah, it's all on
Good. Then get them to me. Get copies to me. Do you understand?
I don't.
That's the first thing. The next thing is the record's going to show a couple of things. Number one, this 23 CR 951 is the first event. And this alleges that on July 2nd, 2023, you were charged with that you committed aggravated assault with a deadly weapon, a second degree felony, with the use of a deadly weapon, namely an automobile. And that was indicted, looks like 3 weeks or so after the event. The grand jury got on that pretty quickly. When were you arrested on that case? Do you remember?
I wasn't.
You never were?
Never.
There was a warrant issued on that day, a capias for you.
Well, I was told the warrant was issued August 9th after I was already arrested.
It was issued the day it was handed up by the grand jury on July 26th.
And I was also told that that indictment was about hearsay and allegations.
Don't talk about that.
But the grand jury indicted you. That's all that's important. The grand jury indicted you. They have evidence, probable cause you committed a crime, period. That's the way indictments work. It's not a debate on what the evidence was, but they handed it up. You're going to interrupt me?
So
No, yeah. You're in trouble. You're in a lot of trouble. The worst thing is to be rude. You get the chance to speak, but don't interrupt me. It seems like that's what you do, is kind of control the environment you're in. We all have a fair opportunity. Don't step on me when I'm speaking. She has to take down everything that's said. When we both speak over each other, she can't do it. When she can't do that job, the Court of Criminal Appeals, the highest court, gets upset with somebody because they say, we want to review what goes on in the courtrooms. But when everybody's speaking over each other, the court reporter can't do her job. So someone gets in trouble. It's going to be you, not me. Do you understand? Don't speak over me. That's what we learned that in first grade. Don't interrupt. You'll get a fair chance to be heard. Okay, so we have an indictment and a warrant pending on July 2nd of 2023. Then on August 6th of 2023, what's that? A month, a little over a month later, it is alleged you committed the first degree felony of murder. Then a warrant comes out on that because that's indicted on August 23rd. So they indicted you about 2 weeks after this. So there are 2 warrants. What was the date he was arrested? Each of these involved.
Day of the murder, Judge.
Okay. Each of these allege you committed violent crimes and used a deadly weapon in each case. So those work against you. When it's an aggravated crime, when there's 2 aggravated crimes, you get double trouble. So what are his bonds on each of these?
50,000. No, it's now, and 1 million on the murder.
And this first aggravated assault, it was alleged that you drove over a human with your automobile, and they were injured because of that. The other motive, you used a firearm in the killing of another human being. Okay. The other seven. Case criminal history here. About criminal history, Mr. Vasquez, anything you want to comment on? Because that's one of the factors in setting a bond is the circumstances of the crime. And in this case, two violent crimes committed within a few weeks of each other. And even aggravating offenses that are from an aggravated assault next to a murder. The court is reviewing a criminal history data. And what do y'all want? Anything you want to say? Because it's four. Well, the criminal history is four. Looks like the defendant was placed on deferred or unadjudicated probation on two cases in 2010, illegal possession of controlled substance and a theft.
That's correct, Judge.
Did he satisfactorily serve those probations?
As far as we know.
Then in 2013, he was convicted of failing to identify. That's a misdemeanor, isn't it?
Yes, sir.
And then also convicted in 2017 for eluding or fleeing a police officer. What happened on those two cases, please, on the controlled substance and the theft? There's F as in Frank 98069 and F as in Frank 10-9188. He was placed on deferred or unadjudicated probation on August 23rd of 2010. Did you serve those out satisfactorily? How long were those deferred? How long was the deferred? Does it show?
I believe it was 5 years.
But he's convicted in 2013 of failing to identify. I guess they didn't revoke him for that.
Yeah, that's a little.
You know anything about that?
I don't.
I think he's acting like he knows.
What? Yes.
I was let off early on probation.
Oh, they dismissed it early?
Yes.
Okay.
Well. The, oh no.
You can get it off. You can get dismissed in a third if you do well. A third of it. So what's a third of 5? 1 2/3. 1 2/3 years. So you're on deferred, and then 3 years later, you're charged with failing to identify so your probations could have ended then. Before
MTRP was filed.
Ma'am?
But an MTRP was filed.
On which case?
The 09-8069.
Yeah, the controlled substance.
But then they did early dismiss his probation in 2013, February of 2013.
What happened in the motion to revoke
So
probation?
I'm assuming it was recalled. In the images.
Okay. All right.
Judge, I will also point out to the court, that's not going to be in that criminal history because it was run when this was indicted. But he has a 2023 offense of discharging a firearm in a municipality that he pled to while he's been in jail.
Okay, it's a class A misdemeanor, isn't it?
Yes, sir.
Okay.
But both on together on probation, so both were dismissed on January 20th.
Do you have a driver's license? Did you have a driver's license? An active, valid one?
Yes, sir.
It was not taken away? It wasn't? You certain?
Yes, sir.
Do you know how many traffic violations that you were charged with between 2019 I'm sorry, between 2007 and 2019, that'd be 12 years. Do you know how many? Yes. I mean, it's your life, you know, but I'm looking at it.
I mean, I don't know how many, but
About how many?
And tickets on it.
About how many tickets would you say you got?
I've been $7,300 worth of tickets.
$7,300? No. So how many separate offenses of operating motor vehicle irresponsible? About how many? You know, it's your life. I know how many I've gotten. Yes.
Don't know.
Well, about when? About how many?
I don't know.
38. 38. That's
From the affected part.
yeah, tickets, and also these are misdemeanors, but it's a whole bunch of them. Plus theft, disorderly conduct, illegal possessions. No, there's a cluster of state jails between charges in 2009, 10, and 11. Anyway, the problem is that for someone, you know, as you from youth, you have been consistent in committing crimes, and these are just getting worse. We go from traffic violations, which are Class C misdemeanors, and now you've got a first-degree felony of a murder, an aggravated assault, a second-degree felony, all within a month of each other. You pick up these, and so the aggravated nature of each of these crimes are most disturbing, and then your criminal history has gone from numerous Class C misdemeanors to now first-degree felonies. And the circumstances of the crime in each case are severe. Your criminal history, even though you're not loaded with a lot of felony convictions, it has been a consistent pattern of irresponsibility in failing to follow the rules. All right, anything else?
No, sir.
Anybody want to add anything?
No.
The court finds that the bonds are sufficient in their amount because the reasons for bonds to be set based upon the circumstances of the crime, in this case, 2 separate serious violent crimes, including a most serious murder. And those are worthy of high bonds to not only show the seriousness of these crimes, but to protect the communities from further criminality of the defendant. Now, we're set for trial coming up, right?
Yes, sir.
Okay, we tried to get it last time, but this is on our radar. So are we going to try the murder or both at the same time?
Just the murder. I plan to offer extraneous evidence of the other.
All right, anything else, Joe?
No.
All right, that is all. Thank you.
Yes.
Next, we got. Y'all getting closer? Good.
Well, we'll let him move to his next contestant. In the meantime, let's go say good morning to Judge Boyd.
Fernandez and Telsey. I don't have Noriega up here, Norma. I think I gave that back to you all.
Your Honor, this is Fred Griffith.
Thank you. Court is calling 2025 CR 003228 State versus Edgar Perez. Can I have parties announce?
Agent Pettis for the defendant.
And are you Mr. Perez?
Yeah, yes, ma'am. Good morning. How you doing?
Good morning. How are you doing today?
I'm all right so far.
All right.
Yeah. Looking forward for today, man. I just woke up.
Okay.
Yeah.
Are you ready to proceed?
Yes, ma'am. Yes, ma'am.
All right. Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am. I understood everything.
Are you the same Edgar Perez who was placed on deferred adjudication in 2025 CR 003-228 for the offense of theft of property 2,500 to 30,000 on April 25th, 2025 for a period of 5 years? Is that you?
Yes, ma'am.
All right, state.
On or about the 22nd day of May 2025 in Bear County, Texas, the defendant Edgar Eliud Perez committed the offense of criminal trespass in violation of condition.
How do you plead to that? True or not true?
True.
All right, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Judge, deny the motion, then petition ISD, follow tap recommendation.
Is that what you're asking the court to do?
Yes, Your Honor.
All right, sir, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am. I swear.
All right, you can lower your hand, state your name for the record.
Edgar Perez.
All right, why are you not doing well on probation? What's going on?
No, I just been having some family problem. I don't like to make excuses, but I've been having some family problem, but
Well, what's the problem? Because they're saying you're doing, you're committing a new offense.
Yeah, it's just because I've been in the street, man, homeless, and I know, it's my responsibility to do probation, but I'm ready to get it done, man. I've been in jail for a long time.
Why are you homeless? What's going on? I know you're homeless because you don't have a home, but
Yeah.
do you not have any family?
Oh yeah, I have family. Like I said, I have some problem with them, but I don't know, man. It's just I don't want to make excuses. I fucked up and I messed up, and I want to get this probation over with. I don't know if you could give me another chance.
All right, so here are your choices.
If I may, Judge.
Well, just 1 second. Have you ever been diagnosed with any type of mental health issue or no?
No, ma'am.
All right, yes, you wanted to say something, counsel?
Judge, the long and short of it is he was homeless at the time. He tells me that he has a place to go to now. And I haven't seen for sure, but I believe some of his family is here, which I believe, is that correct? Some of your family's here?
Yeah.
So
my mom.
Okay, so I believe if he's continued, maybe he'll stay at his mom's house. And
Well,
maybe-
does his mom want him at her home?
I hope so. I don't know.
I don't know,
I
but-
think she's still mad, but I hope so.
Is his mom here?
They might have escorted her to the hall. They might have.
All right. Can somebody check to see if his mom is in the hall? Thank you.
State wouldn't like that language.
All right.
Of course, we have no problems with that if he's continued.
Okay.
Man, can I talk real quick?
Sure.
Yeah, I just want another chance. Last time I was here, I ended up doing 3 months. I did 3 months in county. I'm ready to get this probation over with. I don't want to spend my life in jail.
Well, the best way not to spend your life in jail is to abide by the rules and conditions.
Yeah. Do things right. I just want to.
All right, so your mom is not here.
Yeah, my mom's not here.
So I'm gonna give you some choices today because how old are you?
21.
All right, you know yourself better than I know you. Better than your attorney knows you, better than probation knows you. All right, you're on deferred adjudication. That's not a conviction. So if anybody asks you if you've ever been convicted of, this crime, you can honestly say no, because it's not a conviction, it's deferred. If you receive a conviction, then this is conviction of theft. Whether it's a conviction or not, it's still a crime of moral turpitude, which takes you into collateral issues such as it's going to be hard for you to obtain any type of licensing for anything that requires a license. Now, what I can do is I can continue you, or I will sentence you to 18 months in the state jail facility, give you credit for whatever time that you previously served. So you say you've been in custody for 3 months before, that would go towards your 18-month sentence. Or what I can do is I can continue. I'll deny the motion, alter and amend conditions to include a TAP evaluation in custody. And that TAP evaluation is see if you have any drug or alcohol issues. And I think we're gonna have to do a MIC evaluation in custody as well. So which do you prefer?
I would like, the type evaluation. Like I said, I don't like jail, like everybody else,
I don't think anybody likes jail.
Yeah, nobody likes jail, I wanna be outside, doing my thing, getting money, all that,
Getting money how?
working,
Okay.
working, dealing.
All right.
Yeah, yeah.
So I want to do a TAP evaluation and MIC evaluation. That's to be completed in custody. And have you been using any type of drugs in the past?
No, man.
So why did you become homeless, or how far did you go in school?
Well, I ended up dropping out my junior year, but I just have, I'm gonna be honest with you, I just smoke a little marijuana, but I don't have a drug problem, man.
All right, do a referral to felony drug court in custody. There's going to be 200 hours of community service restitution. You're going to either obtain your GED or get some type of trade school certificate. And once that's completed, the community service hours will be deemed satisfied. Do you have any children?
No, man.
There's going to be proof of employment within 45 days of release, no employment as a home healthcare provider or with minors, regular reporting by Zoom or in person, field visits 1 time per month until further notice. Probation, is there anything else you need? Is there anything else you need from the court in order to be successful?
No, man.
All right, good luck to you.
Thank you.
Thank you.
Okay, before we move to our next court, might I direct your attention to the pinned chat where you will find a link to become a channel member. If you are not already a channel member, you should become one. And I'm serious about that. You really should. Because you get a lot of good extras, but the biggest thing you get access to is the pre-show, which I think is a lot of fun. The members here in the chat can tell you what they think. They've been told to agree, so I assume they're going to. But we do a lot of fun things there, and it's not always just about court. Today we actually reviewed jail statistics across the country and got a little bit of an education, so that was fun. So please do give that a look if you're not already a channel member. It's $2.99 a month. It is not a ton of money, but every dollar of that goes right back into the show to make it better. I don't put any of it in my pocket. I reinvest it. So give that a look. So this is Miami-Dade, where earlier today Judge Glazer was sitting behind the bench as she always does. And then I glanced up and she was gone. And now we have Judge Alberto Millian. I don't know if the hangry just took over or what, but let's see what this guy's all about because I haven't seen him before.
All right, Your Honor, yes.
All right, I do find probable cause as to both counts. The question is how much of a bond?
Your Honor, I believe he has money to pay up to $2,000 or $3,000. My family, like my friends. Okay.
Judge, in terms of criminal history, he was sentenced to 270 days in jail out of Collier County. It looks like it was for obtaining a controlled substance using fraud.
Okay, I'm going to find probable causes to both counts. I'm going to put him on community control or house arrest over the state's objection with a GPS monitor, total lockdown. Alternate bond will be $20,000 per count.
Would Your Honor consider reducing it all?
That's the alternate bond, but you told me he doesn't even have money to make a bond. And I'm putting him on house arrest and now you want me to reduce that. I'm not going to reduce that. Your motion. He doesn't have a good record. You know, he's already been experiencing this. And apparently, according to what I'm reading here, he was doing this for a while. So go ahead, make your argument.
No, Your Honor. Okay, so either you do the house
So
arrest.
Your Honor, is that gonna be with the Nebbia or no Nebbia?
No Nebbia. So it's house arrest, total lockdown with alternate bond will be $20,000. Good luck to you, sir.
Thank you so much, Your Honor.
Good luck to you, sir.
Thank you.
Next case that I have is the Costa Mezquita.
No priors.
Thank you. The Costa Mezquita,
Hey, Judge.
good morning, how are you?
I'm pretty good. How about yourself, Judge?
I'm doing very well, thank you. You're charged in case F2513242 with battery on a law enforcement officer. Having read the A form, I do find probable cause. We set the bond at $5,000 to have no contact with Officer Ramirez. Good luck to you, sir.
I'm sorry, Your Honor, that was 5,000?
Yes, sir.
Thank you, Your Honor.
Lucas Lacerda Lort.
Yes, sir.
Good morning, sir. How are you?
Good morning. All right.
So in case F2513243, you're charged with 1 count of battery on a law enforcement officer. They do find probable cause. Bond is set at $5,000 and you're to have no contact with Officer Ramirez. Good luck to you, sir.
Good talk.
Next defendant that I have is Jaden Jabril Knight. Good morning,
Yes,
sir.
Good morning. Good morning, Your Honor.
How are you?
His bench warrant, they gave him $1 bond on each count.
What on the traffic?
On the M25-10323.
Thank you.
You're welcome.
Sir, on case F2513255, you're charged with the following crimes, 1 count per firearm, possession of ammunition or a gun by a convicted felon or firearm, concealed carrying of a firearm, that's a 3rd-degree felony. The other case is a 2nd-degree felony punishable by 15 years in prison. Count 3, you're charged with grand theft of a firearm. Count 4, that's punishable by 5 years in prison. On count 4, you're charged with tampering with physical evidence. And then count 5, you're charged with resisting without violence. That's just a 1st-degree misdemeanor punishable by up to a year in jail. Seth, can you help me out? How can they charge him with grand theft?
We usually don't, we have to prove that he had knowledge that the gun was stolen. So a lot of times we don't end up filing.
How can we charge him with that?
Let me see.
It had been reported lost, not even stolen.
Right, so we're probably not gonna file on it.
Okay, that's the count 1. I find probable cause. Set the bond at $7,500. That's the count 2. Probable cause. Set the bond at $5,000. Count 3. No PC. Defendant is ROR. Does that to that?
No PC released outright?
Yes, ma'am. Count 4, tampering. I'm going to set the bond at $2,500 on that. And count 5, I'm going to set the bond at $100. Good luck to you, sir. Thank you. Next case is Stephen Bernard Burdell.
You have a bond?
Huh?
You have a bond?
Your Honor, he's on probation cases, they're juvenile.
Thank you.
You're welcome.
Sir, would you tell me what your name is?
Stephen Riddell.
Good morning. How are you today?
I'm good, sir. How are you?
Well, thank you for asking. On case F2513256, you're charged with the following crimes. Possession of a firearm by convicted felon or delinquent, punishable by 15 years in prison. Concealed carrying of a firearm, punishable by 5 years in prison. Grand theft of a firearm, punishable by 5 years in prison. Tampering with physical evidence, punishable by 5 years in prison. And resisting an officer without violence to his person. That hereby is punishable by up to 1 year in the county jail.
Judge, I understand the issue with the grand theft of the firearm. This is a young guy. He turned 18 in March. He's in your division. And he's on juvenile probation for a number of cases.
Well, it's in our division. How would that make a difference?
Because maybe you can keep a close eye on him. He's young. Hopefully he'll be able to turn things around. His history thus far isn't great.
No, he has 4. He's out on probation in juvenile for 4 different cases.
I was hoping maybe you could keep an eye on him.
Thank you, ma'am. I'm gonna find probable cause as to everything but the grand theft of a firearm, which is count 3. So no PC, release outright. Just to count 1, I'm gonna set the bond at $7,500. Count 2, I'm gonna set the bond at $5,000. Count 4, I'm gonna set the bond at $2,500. And as to count 5, I'm gonna make the bond $100. Good luck to you, Mr. Riddell. It seems like I'll be seeing you soon.
Thank
Well, I will say this. He runs a much calmer and friendlier courtroom than Judge Glazer, perhaps. So good on him. Let's go back to Judge Boyd. Let's do that. Let's make that happen.
To have Mrs. They may end up working out an agreement. Is it best for her to go back to the jail and then do Zoom from the jail? All right, so they're going to send you back to the jail.
Okay.
And then they'll have you on Zoom to speak with your attorney in one of the breakout rooms.
No problem. Thank you so much.
You're welcome.
Okay.
And then we'll call you and let you know, Hunter.
Okay, Judge, and is this something that we wrap up today? I have an offsite for this meeting this afternoon, 12:15.
Okay, well, we'll play it by ear, see where you are.
Okay. Thank you.
All right, thank you. And if you're unable to make it, just let us know.
Yes, ma'am.
All right, thank you.
Judge, will they give information on that Zoom hearing?
Yes. And Hunter, if you can speak to Ms. Ferguson about what the offer may be, I'm not allowed to know what it is, so.
Yes, ma'am.
All right, thank you.
Well, that was pretty much nothing. Sometimes that happens. Let's go to Judge Stevens.
Yes, you're gonna have to get a thumbprint with her in a minute. Yeah, stand by. They're fixing the papers. They'll just take a couple minutes. Thank you. Sorry about that, Sonny.
Yeah, I can do it, ma'am. You go, man. Straight up and down.
Milton, who's called earlier from documents here now.
Okay.
Same phone.
We get on the license rate included. This is class A, so.
Straight up there.
He's covering my. And he was a veteran. Lived on the lot type.
She was yesterday, I had it today, so she was on forfeiture.
Okay, who's her attorney?
It's Don, but because of Jim and Dave wrong, I couldn't get Don here today, that she needed to appear.
What's sorry?
It's initial vetting, to double check.
Can I you get the file? Is that it? Thank you. So there are 2 cases?
Yes, sir. I'll find the file.
Mr. Smallwood, just wondering if you were asking. No, I was looking at Miss Middleton's.
2 copies.
Can you call her?
Perfect.
Mm-hmm. Yeah.
Think of in town. I got reference.
Judge, this is a plea on the lesser included.
Yeah, I'm looking at this lady right here. From probation, we're gonna need some help. Yeah. Okay, on Bandon Smallwood. Yes, sir. Mr. Smallwood. Okay, we now call 25 CR 505, the state of Texas versus Bandon Smallwood, who is present with Mr. Lane, his attorney, and the state's attorney. The defendant is charged in an indictment here with the third-degree felony of assault of hospital personnel on hospital property. And let me see, there is an plea agreement. Let me look at it real quick where we're headed on this. I say misdemeanor of assault. Right?
Yes, sir.
Okay. So the defendant is going to be pleading to the lesser included Class A misdemeanor of assault, which is within the wording of the indictment where it is alleged the defendant intentionally, knowingly, and recklessly caused bodily injury to another person.
Yes, sir.
And because we're dropping who the personnel and employee who was the victim, who has special protection under rule of law because of their job, that would have enhanced it to a third-degree felony. So you're going to be proceeding on the lesser included Class A misdemeanor of assault, which carries with it up to 1 year in the county jail and or a fine up to $4,000. Do you understand what you're facing, sir? Yes, sir. An agreement has been reached in your case that you would be placed on deferred or unadjudicated probation, which can be up to 2 years in length, right?
Can be, Judge.
And was there any restitution here?
No, sir.
It's up to the court's decision on the length of probation, but it would be deferred or unadjudicated probation where you would not be found guilty so long as you followed the conditions and terms of probation. If you failed, your probation could be revoked. You could then be found guilty and sentenced up to 1 year in jail. Do you understand?
Yes, sir. Just in light of that, Your Honor, Mr. Smallwood, he is a disabled veteran with schizophrenic disabled veteran.
Is he competent?
Yes,
he wasn't acting insane at the time. He's not insane at the time.
Absolutely not.
Okay.
No.
Well,
no, I feel that the judge is going to do something beyond our agreement. That's all.
Like what?
Like make the term 2 years instead of 1 year deferred.
Well, that's what I can do.
You're all right. He's just trying to convince you.
But I can also shorten it.
Yes, sure.
For good behavior on probation.
We have no objection to that.
Yeah, which I do it literally every day.
I know.
Every day. Just.
This was at Baptist Behavioral, Judge.
I understand. And what I want to do in making rulings like this is the rights of the defendant are foremost because it's constitutional. On the other side of the coin, we have victims who feel like when you're caring for people who are sick, that's a most wondrous profession. We don't want people to say, I don't need this anymore if I'm going to get kicked in the face.
I agree.
Like what happened here. And they're going to know from what I do that they're protected as victims and you're going to be held accountable fairly. But, they don't get paid to get punched or in this, I'm sorry, this was kicked on the right side of their face, causing them pain. They're doing you a favor. They're taking care of you. It's a most wondrous profession. I don't want people going, I don't need this because I'm not protected. All right. You have to pay. And these are wonderful professions. And the people need to be taken care of. But I'm going to follow the agreement, but they're going to know. I mean, you're going to be put on probation for 2 years. You do well, I'll shorten it as a reward. Okay. And we can do it in a third of the time.
Thank you. Do you understand? No. So you know that.
Just don't do this, please. I mean, don't hurt people, especially people who are doing God's work by helping other humans and trying to care for them. And if people said, we're not going to do this job, we're not going to do this because people kick us in the face, then what happens when you have to go to the hospital? Nobody's there to take care for you. If I follow this agreement, which is placing you on deferred or unadjudicated probation, and again, there's no restitution here, correct?
That's correct, Judge.
And this can be up to 2 years in length. If I follow this, sir, which I intend to do, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this lesser included Class A misdemeanor of assault? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'm going to show you here what's marked in State's Exhibit 1. Did you sign that document?
Thanks.
Voluntarily? Did you understand it? Discuss it with your attorney? Or the contents all true and correct?
So,
State's Exhibit 1 is tendered into evidence.
no objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. The indictment's been read to you, or you've read it. You are guilty of the crime charged and any lesser included offenses like the one you're pleading guilty to, the lesser included Class A misdemeanor of assault. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true, it states, so help you God.
Sir.
State's Exhibit 1 is made a part of the record for all purposes.
No objection.
Pre-sentence report is waived.
It is, Your Honor.
I'm going to follow this agreement, and on a 2-year, if he's placed on 2 years probation, is we can shorten it to 1/3 of that too, right? Which is 8 months.
Yes, sir.
What I want though is also on this probation, we've got to take care of certain things that put him in this situation. Do you take regular medicine or something?
Yes, sir.
You do?
Yes, sir.
Okay, you're going to have to continue to take the prescribed medication as it is prescribed. Don't fail to do that.
Yes, sir.
Was that a problem here in this case? Did you fail to take the medicine on time or something? Maybe, I don't know.
He went in to the hospital for an episode of a mental episode, and I think this all kind of sprung out.
Okay, what about is there a program for folks who have, we need to know what it is for his mental issues that he is being handled with so that we can make sure that he continues and maintains whatever assistance he's getting.
That would be the mental health caseload, Judge.
I think she.
Okay, he's on there. We'll put him on there. Okay, good. That ought to take care of it.
Yes, sir.
But take all your medicine and make sure. Now, what happened? You get this from the military?
Yes, sir.
Were you affected? What were you doing? Were you in? Where did you go?
So Kuwait.
Kuwait.
Yes, sir.
Okay. And were you injured there?
Yes, sir.
Yes, sir. But it wasn't a friendly place, was it?
No, sir.
That was very dangerous. Yes, sir.
I scan people in with the wine and stuff like that.
Sir?
I scan people in with the wine, look for camera and stuff like that.
Yes, sir. But this medicine that you're taking helps you, doesn't it?
Yes, sir.
But you got it.
Stay
Yeah.
consistent.
doing that as prescribed. That's going to be important for your probation.
Yes, sir.
It helps you be the best you can be. Okay. I think it's in his best interest that we do as long as we can, just to help him. Because we don't want him to backslide. All right, I'm going to follow this agreement and find there is sufficient evidence supporting this agreement from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, as you are mentally competent to enter your guilty plea and it's freely and voluntarily made. But to find you guilty beyond a reasonable doubt, there's enough evidence here, but I'm not going to find you guilty.
Yes, sir.
So long as you follow these terms and conditions of probation, you get another chance.
Yes, sir.
It'll be for 2 years or less. And there will be terms and conditions of probation, which are normal and customary for this type of situation, including you will be completing an anger management class and also be placed on the mental health caseload. And also it goes without saying, God bless you, whatever you've been prescribed for medicine or for your medical needs, you must follow those prescription requirements and take your medicine as required. Okay. And then everything should be fine. Okay. You're going to be released here. And what are you going to do next? Do you work somewhere?
Sure.
Are you looking for something for employment?
Currently work, disability and SSDI.
He's married, Your Honor. I've been in pretty constant contact with his wife. They were in Florida.
Living?
I believe, yes. And
they're back?
Yes. So I think they're going to have to establish another residence. And I've told them they'll have monthly reporting duties to Jefferson County and to wherever they're going to go permanently.
Okay. Does your wife work? Is she employed?
No.
Nobody's employed in the house?
I'm just receiving disability.
Yes, sir. I understand, but I know a lot of people who are disabled who are employed and do things.
I would like to work.
You would? Good. Well, don't think you can't do it. If you're capable and you want to do it, you can do anything you want. As long as it's following the rules and not hurting others. But working helps the world and helps you. It makes the world a better place by you getting involved and doing good things. And then getting paid for it. Things you like. Okay. All right. But anyway, work with your probation officer. They're very nice people and they'll help you along. Good luck. Yes, sir. Okay. Take that medicine in.
All right, let's stay in the same building, but we'll go over to Court at Law number 2. This is Judge Terrence Holmes, a.k.a. Judge Rubber Gloves. Let's see what he's got going on today.
25 CCCR 1056, case is styled the State of Texas versus Keith Jonathan Green. Mr. Green, is that your full name?
Yes, sir.
Mr. Green, would you please raise your right hand? Mr. Green, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Green, you may put your hand down. How are you doing, Mr. Green?
Doing fine. How about you, sir?
I'm doing fine, thanks for asking. Mr. Green, you're represented in your case by your attorney, Joe Vasquez. Mr. Vasquez, do you waive a record in Mr. Green's case?
Yes.
Mr. Green, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Green, it alleges that you, Keith Jonathan Green, on or about March 15th of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense or failed to identify by giving false or fictitious information. Mr. Green, do you understand what you have been charged with?
Yes, sir.
To this charge, Mr. Green, how do you plead? Guilty, not guilty, no contest? Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charge?
Yes, sir.
Mr. Green, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. You recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials on the line next to boxes checking the look injury. Place your initials on this document.
Yes, sir.
On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box is checked, states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Sir.
I also have a document on paper that's titled discovery certification. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant? And Mr. Green, before you signed and initialed all of these documents that I just showed you, did your attorney go over these documents with you?
Yes, sir.
Did you understand everything that your attorney went over?
Yes, sir.
Is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Sir.
Mr. Green, are you a citizen of the United States?
Yes, sir.
State offer states one.
No objection.
No objection. States exhibit number 1 will be admitted. Mr. Vasquez, you advised and counseled Mr. Green. Is there any evidence that he is currently mentally incompetent to stand trial?
No.
Mr. Green, your attorney, Mr. Vasquez, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Green, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state's offering 18 days in the Jefferson County Jail, credit for time served, and tax and retired court cost.
Okay, Mr. Green, the state is offering that you serve 18 days in the Jefferson County Jail, but you will not have to serve any more time in the Jefferson County Jail. On this case, because you've already served 18 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Mr. Green, do you understand what you have the state's offer?
Yes, sir.
And do you think that the state's offer is fair and just?
Yes, sir.
And do you accept the state's offer?
Sir.
Mr. Green, I'll follow the plea bargain agreement that you have entered into the statement. Mr. Green, if you do not have anything else holding you in jail, you should be getting out of jail today. Mr. Green, please stand next to the bailiff, follow her directions. Once you're finished following her directions, you'll be free to follow the bailiff when you have a blessed day. Jonette Johnson. Jonette Johnson.
Have a good day, sir.
All right, same to you.
I think I can get away with it. Told you about the lawnmower.
I'm gonna kick you. You told me several times.
It's a big day of my life.
It's a big month. Oh, right.
I could just get a chance to use it. We don't want to use it once.
Water.
Good morning.
Good morning.
Again.
Jefferson County Court Law number 2 is in session and calls number 25 CCCR 0222. Case is styled the state of Texas versus Jonette L. Johnson. Ms. Johnson, is that your full name?
Yes, sir.
Ms. Johnson, would you please raise your right hand?
Yes, sir.
Ms. Johnson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Johnson, you may put your hand down. How are you doing, Ms. Johnson?
Hi.
That's good. Ms. Johnson, you're represented in case by your attorney, Joe Vasquez. Attorney Vasquez, do you waive a record in Ms. Johnson's case?
Yes, sir.
Ms. Johnson, I have before me a document that is titled information. This information is on my computer. It was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Jonette Johnson, let me check about something here. It alleges that, you, Jonette Johnson, on or about December 27th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of failed to identify fugitive with intent to give false information. Ms. Johnson, do you understand what you have been charged with?
Yes, sir.
To this charge, how do you plead? Guilty, not guilty, no contest?
No contest.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Ms. Johnson, I also have a document on my tablet that is titled Misdemeanor Pre-Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, Ms. Johnson, there are a set of initials on the line next to a box that's checked no contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there is a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled
Yes,
Defendant?
sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Now, Ms. Johnson, before you signed and initialed all of these documents that I just showed you, did your attorney, Mr. Vasquez, go over these documents with you?
Yes, sir.
Did you understand everything that Mr. Vasquez went over?
Yes, sir.
Is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes.
And Ms. Johnson, are you a citizen of the United States?
Yes, sir.
State offer States 1.
No objection.
No objection. State's Exhibit Number 1 will be admitted. Mr. Vasquez, you've advised and counseled Ms. Johnson. Is there any evidence that she is currently mentally incompetent to stand trial?
No, sir.
And Ms. Johnson, your attorney, Mr. Vasquez, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Ms. Johnson, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
What is the agreement?
In exchange for defendant's plea, the state's offering 17 days in the Jefferson County Jail, credit for time served and tax and retired cost.
Ms. Johnson, the state is offering that you serve 17 days in the Jefferson County Jail, but you will not have to serve any more time in the Jefferson County Jail because you've already served 17 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Ms. Johnson, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
Do you accept the state's offer?
Yes, sir.
Ms. Johnson, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Johnson, if you do not have anything else holding you in jail, you should be getting out of jail today. Ms. Johnson, you're going to stand next to the bailiff. Follow her direction. Once you finish following her direction, you can follow the bailiff, and you have a blessed day.
Okay, let's clear this up a little bit because Ashley's got questions about him using the word taxed. So I just did a little bit of research because he's saying court costs taxed and retired. In an illegal context, that means that the court costs associated with the legal proceeding have been assessed and documented by the county clerk, and the process for recovering or settling those costs have been completed or is being handled. Specifically, taxed taxed refers to the process where the court clerk officially determines the amount of the cost to be awarded to the prevailing party. And that can include various expenses such as fees for officers or witnesses, costs of depositions, compensation for referees, cost of certified copies, jury fees, and other fees. And then retired indicates that the costs have been paid, discharged, or settled. So not exactly taxed in the normal sense, but that's the breakdown of what he's trying to say. So hopefully that helps. We always try to learn here at TCF, in case you haven't figured that out yet. Let's go to Wisconsin. Let's say hi to Judge Mogan.
We will go on the record in the matter 24 CM 196, State of Wisconsin versus Scott Lang. The appearances are Mr. Lang appears in person with his counsel, Christopher Gramstrup, in person. We have the state appearing through District Attorney Kevin Schmidt. We're set today in this matter for a plea and sentencing, and that is proceeding as such, correct, Mr. Gramstrup?
Yes, Your Honor.
And I do have a plea questionnaire waiver of rights form in front of me. Mr. Lang, do you recognize this document?
Yes.
And did you sign this document? Mr. Gramstrup, can you please recite the agreement for the record?
Your Honor, Mr. Lang would be pleading guilty to count 1. Count 2 would be dismissed outright. There's a joint recommendation on count 1 for 1 year probation, 4 months county jail as a condition imposed and stayed, no sentence credit due.
Okay. All right. And so, Mr. Lang, you indicated that your attorney went over this document with you. Did he go over it thoroughly?
Yes.
Did he essentially go over it word for word?
Yes.
And do you understand everything on this document?
Yes.
It states that you're going to plead guilty to 1 count of violation of an injunction restraining order. You're 59 years old. You have 10 years of schooling. You can read, write, and you understand the English language. Is that correct?
Correct.
Your attorney went over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
And did your attorney go over with you the maximum possible penalties you face?
Yes.
You're not receiving treatment for mental illness or disorder, no alcohol, drugs, or medication.
No.
Because you're charged with crimes, you are entitled to constitutional rights, and each of the rights is listed on this document. Did your attorney thoroughly go over those rights with you?
Yes.
Do you understand them completely?
Completely.
Do you need me to go over those rights with you in any more detail?
No, ma'am.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
You understand that here the state must prove for count 1 violation of an injunction harassment that on or around Monday, July 8th, 2024 in Burnett County, Wisconsin, you knowingly violated a harassment injunction. Do you understand what the state would have to prove?
Yes.
Do you understand that upon conviction, you face a fine of up to $10,000 or imprisonment of up to 9 months or both?
Yes.
You also understand that there is a recommendation, a joint global offer that you've reached, where there would be a recommendation to the court for 1 year of probation with an imposed and stayed sentence of 4 months in jail. Do you understand what that means?
Yes.
Do you understand that I'm not bound to follow that recommendation?
Correct.
If I thought based upon the facts that it was more aggravated or that you deserved or should get a harsher punishment, do you understand I could sentence you to the maximum penalty?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did your attorney go over the criminal complaint with you?
Yes.
In particular, there is that section called the probable cause section where it basically says what happened and why you were charged with the crimes. Do you remember reading that and going
Yes.
over it? For the most part, as it relates to the count you're pleading to, are those facts accurate?
Yes.
Mr. Gramstrup, did you thoroughly go over the facts that are alleged in the criminal complaint with Mr. Lang?
I have, Your Honor.
And do you believe he understands those facts and what the state would need to prove the elements of the charge?
I'm quite confident that he does.
May the court use the probable cause section of the criminal complaint to find a factual basis?
Yes.
Has anyone made any threats or any promises to you, Mr. Lang, for you to plead guilty today?
No,
You're doing so freely and intelligently, telling the court you fully understand what you're doing
yes,
and voluntarily?
yes,
Has your attorney represented you competently?
yes,
Has he answered all of your questions?
yes,
Has he looked at this matter and the discovery and the evidence and discussed it with you?
yes,
Has he discussed with you a potential for any defenses or a lack of defenses in this case?
yeah, we discussed it all.
And are you satisfied with his services?
Yes,
Do you have any questions for the court or for your attorney before I proceed?
no,
As to count one, violating a harassment restraining order injunction, how do you wish to plead?
guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count one. Count two will be dismissed outright. A judgment of conviction will be entered today. We do have victim who is present here. Does victim wish to make a statement? All right, the victim can come up to this black little desk and you can either state your name or your initials, whatever you feel the most comfortable, and provide your statement.
Marissa Brianne Rist, R-I-S-T. I write this with the burden not only of my own experience, but out of the accumulated fear, anxiety, and harm carried by others who've had the misfortune of encountering Scott Arlen Lane. What I detail here is not theoretical. It's a chilling and relentless pattern that stretches across nearly 4 decades. I ask the court not to consider this man in isolation, but in the context of his life's choices, a legacy of violence, threats, manipulation, and a brazen disregard for the law. Let me begin with this. Scott Lane is not rehabilitated. He is not misunderstood. He is dangerous. His criminal history isn't abstract. It's a 23-page document that I have with me today of convictions of court filings that include, but are not limited to, second-degree murder, felony strangulation, felony domestic violence, assault on a peace officer, drug possession, fleeing police, multiple counts of violating no contact orders, criminal damage to property, harassment, and disorderly conduct. Repeatedly, in almost every instance, the response was probation or supervision, which he's violated more than a dozen times. Statistically, the risk associated with this level of criminal history is staggering. A study by the U.S. Sentencing Commission found that individuals with more than 7 prior convictions have a 61% likelihood of reoffending. Scott Lane's record exceeds that threshold by a wide margin. He is not a former offender. He is a persistent, ongoing one. The violation in front of the courts today was not a one-time incident, but rather just one more chapter in Scott's long, escalating pattern of violence. A previous prosecutor had stated on Scott's past charges, they reflected ongoing themes of violence, confrontation, and paranoia. On April 12th of 2018, the state on record stated that they recognized these as persistent patterns, and they are still present today. On June 26th, 2025, in yet another courtroom, in yet another criminal case involving violence and confrontation. While previously incarcerated, Scott had been removed from a jail treatment program for physically assaulting another inmate, further demonstrating his inability to manage aggression, even in a controlled environment. He has repeatedly told others he has a target on his back and that the murder was in the past, as if that absolves him. But when angry, his instinct is to weaponize his past, and he said to me directly, "Do you know who the fuck I am? Do you know what I did?" A chilling reminder that he uses his violent history as a tool of intimidation. Scott is on body cam stating, "I am starting a plan. I ain't playing this game with her. She's going to be dealt with. I have connections. Fuck her. She is the most worthless bitch I've ever known. Let her know I'm done and I'm going to make plans if she doesn't get the fuck out of my life. I'm getting the fuck out of here because I don't want anything bad to happen, because I know what the fuck's going on in my brain. I'm gonna fucking study the fucking house and I'm gonna make some inquiries. You think 30 years in fucking prison, being with PBMs, Hell's Angels, I don't know, fucking connections? She should be smart and move the fuck out of here. Scott has bragged about killing Deputy Michael Moreau, not only to me, but in other criminal cases where he threatened a Menards employee, stating he had killed a cop and that people should be careful around him. These are not the words of someone seeking redemption. They are the boasts of someone who sees past crimes as leverage. While these cases may not be the direct subject of today's hearing, they remain highly relevant to his behavior and his mindset, which continue to demonstrate he is unrehabilitated and is incapable of becoming a productive member of society. Scott is admitted to drinking and using substances. Scott has used alleged substance abuse to justify previous convictions. His paranoia is well documented in decades of police reports and court transcripts. He will frequently claim people are out to get him or that he's being targeted. He's, again, even claimed to have connections to kill people, a statement that should raise immediate concern for anybody who is tasked with protecting the public safety, anyone who represents the courts that's sitting in this courtroom today. Violating probation is not just a minor slip. According to a research published in Criminal Justice and Behavior, each infraction during probation increases the chance of reoffending by 700%. Scott's repeated violations, including substance abuse, no contact violations, and threats, they are not technicalities, they are predictors of future behavior. In a Minnesota court transcript, a jail call is referenced in which Scott contacted the very wife he claims to love who is sitting in this courtroom today. Immediately after Danko was dismissed, Scott asked Roxy to put her son on the phone and said, apparently there's some problems at home. He insinuated his stepson would be assaulted, implying retaliation or violence was imminent upon his release. He called Roxy again on another number, referring to her son as the spawn of Satan, and continued to berate her. All of my problems started when I met you. You're so messed up you could ruin a wet dream. This is not love. This is coercion, manipulation, and control. Again, consistent themes in Scott's behavior. If Scott is willing to treat the people he loves this way and states on body cam, I might only have 6 months or a year. I'm trying to make as much money for my wife. I'm trying to set up my wife the best I can. What is he capable of doing to someone who he has no feelings or relationship for? Someone he does not love or care about? In 2024, in this very courtroom, in front of you, Your Honor, I was issued a 4-year injunction against Scott and Roxy Lane. During this time, Scott had retaliated by making false allegations and filing a false restraining order against me. Scott was aware of the restrictions this injunction ordered. However, despite that injunction clearly prohibiting contact, he committed 2 new violations on July 8th and September 26th, resulting in why we are here today. On July 8th, he fired explosives, also known as fireworks, at my home and vehicle, striking my home and my car. When it hit my home, it was loud enough for my children and I that we thought bullets had came through our home. My children were terrified. Scott had admitted to being intoxicated and told officers he was done playing and had connections and was going to go out with a bang. He said he was starting to plan and that I, Marissa, was going to be dealt with. These are not idle threats. They're the words of a man who's already killed, strangled his wife, and physically abused not only his daughter, but his stepchild. On September 26th, he and Roxy Lane drove into a restricted area in direct violation of the injunction. Both parties were subject to active court orders. I again provided video evidence to law enforcement. This was not a misunderstanding. It was a calculated act of intimidation. What Scott and Roxy fail to realize is that my home is equipped with a professionally monitored surveillance system. A security company provides 24/7 active monitoring, always recording and reviewing footage. Even when I'm not home, I have full remote access that I can monitor every angle of my property, the front, the back, the sides of the house, the garage, the parking lot, across the street, and even the surrounding fields. In addition, there's multiple trail cameras throughout the fields for added coverage. There is no uncertainty that Scott was caught. The footage is clear. This is not a matter of opinion or debate. He may have attempted to claim it was his brother Gary, but that argument does not hold, as our family has known both individuals. We know what Gary looks like. We've seen him at Scott's residence. Furthermore, Gary has a criminal record with an official mugshot, making it unmistakably clear that they are not the same person. Attempting to confuse or deflect responsibility in this way is just another manipulation tactic, and one that fails in the face of documented evidence. Even with my restraining orders in place, Scott has continued to stalk me. He's entered my driveway, harassed family and friends, used his wife to deliver a 20-page handwritten letter defending his actions and accusing me and my church of worshiping the devil in the basement. This is just not harassment. It is now psychological warfare. Law enforcement has been called to Scott's residence other times within the past year for incidents involving domestics and violence towards others that I've witnessed Burnett County Sheriff's Department at his home for calls that I did not initiate. On several occasions, Roxy had also reached out to me in fear, admitting that Scott was back on methamphetamine, asking for help to get him out of the house. She had specifically requested resources from me, knowing I was working in the capacity of a legal advocate in the court system, further underscoring the seriousness of her situation and the danger she felt. Scott had moved to this town with the intention of hiding his past, but when someone, not me, uncovered it and the community began to learn the truth, he spiraled. Instead of seeking redemption, he chose retaliation. Scott alleges we were friends until I heard 35 years ago he killed a cop. What Scott fails to mention is, I discussed this at great length with Scott and Roxy, and I informed him I in no way supported his past choices. However, I can recognize he served his time and had not harmed myself or my children. He also fails to mention he and his wife had brought us over a handmade cake, snacks, and a handmade holiday card after this exchange, as we had put this behind us in an attempt to move forward. Many people ask why this betrayal cuts especially deep for me. It's because I've spent my career working in reentry services, helping formerly incarcerated individuals reintegrate into society with dignity and respect. I've also worked on the other end of victim advocacy, helping survivors find their voice. I firmly believe in second chances, and I firmly believe in rehabilitation. Had Scott shown a shred of respect for me, my family, or this community, I would have been probably among the few willing people to stand behind him and offer him that chance to prove redemption. But he didn't. He weaponized my compassion. He used proximity and legal loopholes to terrorize me. Multiple other district attorneys' offices, time and time again, have failed to protect the many victims who have suffered under Scott's ongoing reign of violence. Even today, the proposed plea deal of 1-year probation is not just inadequate, it's dangerous. It sends a message that victims don't matter. Threats don't matter, and the system will always bend for convenience. It sends another loud and clear message to Scott that he got away with it again. While this case isn't resolved today, Scott faces new criminal charges also in Kanabec County. He was charged with 3 counts of disorderly conduct, including brawling or fighting from an incident on August 15th of 2024. That jury trial is scheduled for August 18th this year. This is not a man learning from his mistakes. This is a man who continues to reoffend even while under court supervision and on bail. He is not just a repeat offender, as I stated. He is a current offender. The danger he poses again is not theoretical. It is real, active, and continues to escalate. According to the Bureau of Justice of Statistics, over 70% of state prisoners are rearrested within 5 years, and violent offenders are rearrested at even higher rates. When you factor in repeat domestic violence, strangulation, criminal threats, those odds continue to rise dramatically of reoffending. This court must recognize that probation in Lane's case is not a rehabilitative opportunity anymore. It is a revolving door that places victims and the communities that we all directly live in harm's way. Under Wisconsin Statutes, Chapter 973, this court has the authority to depart upward from any sentencing recommendation when aggravating factors are present. Scott Lane is a habitual offender and has shown no remorse, no accountability, and no willingness to change. He's a danger to me, to my family, and to every member in this community. Probation is not justice. It is not safety. It is not accountability. If this plea is accepted, what message are we sending to victims? Is our safety negotiable? That the hours we've spent filing restraining orders, calling in the police, appearing in the court, collecting evidence, and reliving trauma in front of strangers, does that mean nothing? That abusers who stalk, assault, and terrorize can walk free with just a signature and a promise to behave for another year? That this abuse is negotiable, that even the most credible threats and repeated violations are nothing less than paperwork. That's not justice. It's traumatization by the process. Every time the system chooses expedience over accountability, it erodes public trust and inflicts fresh wounds on those who have already suffered. We're not just reliving our trauma, we're forced to participate in a system that looks the other way while it happens again and again and again. You're telling those who have endured physical and emotional abuse, those who've had fireworks launched at their homes, who've been stalked, threatened, silenced, those who have been murdered, that their fear is less important than court efficiency. You're telling future victims to brace themselves, not just for the violence, but for the system's dismissal of the violence. If this plea is accepted, everyone with the authority to act and hold Scott accountable becomes complicit, not just in failing to act, but in granting permission for the harm to continue. But you, Your Honor, you're not bound by that failure. You have the authority to reject this plea and impose a sentence that reflects the gravity of Scott's ongoing actions and ongoing threat he poses. I urge you to consider the full weight of his history, his choices, and the lives he's impacted. This is not just about punishment, it's about prevention. It is about sending a message that the victims matter and that their voices matter and that my voice matters, and that the system will not tolerate those who continue to seek to harm others, manipulate, intimidate, and break the law. I would ask that Scott be remanded for the full 9 months, if not longer, and taken into custody today, as well as a DANCO or no contact order be updated to include my minor children as they were listed in the criminal complaint and do not have protective orders currently in place. Thank you for your time and consideration. Thank you.
Thank you.
All right, Mr. Lang, that was not appropriate. Is this funny?
No,
Don't do it, Scott.
no, it's not.
All right, Mr. Schmidt, argument from the state, please.
Duty of candor before the tribunal, reviewing his criminal history. The victim related that she believed that he has criminal convictions for harassment and strangulation. I do not see those. I know nothing about the actual facts she states of his past criminal convictions. And the court obviously can't consider any pending case in Minnesota for, I think she said, disorderly conduct. So we know how we do sentencing here. The court must first consider probation unless if it unduly depreciate the seriousness of the offense. This is not a violent crime. This is not a murder. This is not a domestic violence offense. The victim got a restraining order against her neighbor, and her neighbor fired fireworks towards her property. This would be probably a fine case if not for the fact that, as the victim said, Mr. Lang does have a criminal history. That is how this is aggravated to require probation with the 4 months state and imposed jail, given what the violation was, firing fireworks towards his neighbor's property. I understand that this is intensely personal for the victim. It's very clear that in addition to her feelings and her experiences with Mr. Lang, she's actually gone the extra mile to really dig in and research everything she can about Mr. Lang. But that's not really what the restraining order cases are about. Restraining orders come about, harassment restraining orders come about when relationships deteriorate to the point where people can't get on anymore. So they go to a court, and if they meet certain criteria, the court does an order that says you can't do certain conduct. The goal is to cause both individuals to live peacefully in the community with no further issues. We have a criminal offense for when people violate that in Wisconsin. That criminal offense is not organized in the public safety section or security against bodily harm section. It's located in the same section as contempt of court, because that is what the primary interest is of the restraining orders. Someone has violated an order of the court. That is where the criminal penalties derive from. That is what it's structured after. That's why in this case, doing this probation to make sure things don't go on, having conditions of probation to not have contact with the children as well, so there can be no wedging, and to have some sort of absolute sobriety in this case. Mr. Lang did say that he was buzzed, and I think that was probably a connection to why he made the decision with the fireworks in this case, would be appropriate and would protect the public. It would give the victim a means to have a faster means of reporting future violations in the future. And it's the appropriate way to structure what the violation is. We don't go from complaint to injunction to 9 months jail. We go from complaint to injunction to some other penalty, and we have to ratchet up penalties. We don't do them. We don't punish individuals. We punish crimes. Mr. Lang does have an extensive criminal history. It is very serious and it's very violent. The last criminal conviction he has would have been in 2017, meaning he's already beaten those statistics about recidivism within 5 years. And that's another reason why we should believe that probation would be successful. I'd ask the court to follow the agreement and remember that this is a violation of a restraining order where someone fired fireworks at their neighbor's property in the context of escalating personal relationships between them. There's no domestic history between these two people. There's no past violence between them. That is what this case is. Thank you.
Thank you. Mr. Gramstrup?
Thank you, Your Honor. First, I would indicate that I agree with everything that the state just indicated. First of all, this is a misdemeanor. It's a Class A misdemeanor. Mr. Lang is 59 years old. He's married to Roxy. They've been married for 9 years. Despite what some of the court, what the court heard today, my understanding and my observations is they have a loving and caring relationship. She's an RN. She's a professional. I see no problems in their marriage at this point. He's got 2 daughters. He does have a record, as the state indicated, his last conviction was in 2017. He works side jobs as a mechanic type work on cars. He does have a heart issue that he's being treated for. Got no mental issues. He had a heart attack a few years back, and they're treating him for a heart valve issue. He likes to spend his free time working on cars, particularly classic cars, and bird watching. Does a lot of bird watching. I would indicate to the court, and the court's very familiar with me. I do not attack victims. Victims, I believe very strongly, have the right to say whatever they want to say at the sentencing or at any other point. But I'll leave it at this. I do disagree with factually a lot of the things that were stated as facts by the victim. I know, as the state indicated, that not everything was entirely accurate. This case, from my perspective, Your Honor, was a very triable case. And having count 2 dismissed outright was important in the resolution of this. I know what the victim indicated about the video. I've seen the video. And I would be very confident in taking this case to trial. I put cases, basically, when I take a new case, Your Honor, I put them basically in my mind in 3 categories. The first is this case is not likely to ever go to trial. Then there's sort of a median where it could, it might not. And then there are cases where I think initially this is a case that's probably going to get tried. And after my first conversation with Mr. Lang, that's where this case was. I thought it was very likely headed to trial. But he wanted to accept responsibility here. He, again, especially as it relates to count 2, there would have been in my opinion, very credible testimony that that was not him driving the vehicle. And not just from the person that was in fact driving the vehicle, but from other people as well. And I've seen the video. His brother and he do look very much alike. I think it was very triable on count 1 as well. Now, no case is perfect. There are things on the other side that Mr. Lang and I talked about. And ultimately he said, I don't want to put the county through this. I don't want to put witnesses through this. I just want to get this behind me. His words were, I want to leave her in peace and I want her to leave me to live in peace. That is his impetus for pleading today and moving forward. Since the injunction was filed in 23 CV 102, there have been dozens of calls to law enforcement about Mr. Lang, many of them completely unfounded. Whenever there's a dog running loose in the neighborhood, they show up at his door and accuse him of his dogs running loose when they're not. There was an incident where the police were called on report of a domestic because they heard him cursing and swearing. He was cursing and swearing. He was working on a car and was having difficulty, and he was losing his temper at the car and cursing and swearing. He was out in the open doing that. His wife wasn't even home at the time. So there have been dozens of calls that have not resulted because they're unfounded in accusing Mr. Lang of doing things that he just hasn't been doing. Again, he wants to leave her in peace. He wants her to leave him in peace. He wants this behind him, and that's why he's entered a plea today. He's accepting responsibility. He just wants to move on. I believe that the agreement that we have before the court is entirely reasonable. 1-year probation on a case, in my opinion, again, that was very triable with 4 years hanging over him. It's got some teeth to it. So I would ask the court to approve that agreement. I think it's entirely fair and reasonable and meets all ends of justice.
Thank you. Just to correct you, it's 4 months.
I'm sorry, what I said 4 years. I'm sorry, I misspoke.
I knew what you meant. I just wanted the record to be clear.
Yes, thank you.
All right. Mr. Lang, I'm now going to turn to you and I'm going to ask you if you wish to provide a statement to the court. You do not have to, but it's your only time to let me know anything that you believe that wasn't stated correctly or that wasn't stated at all, or anything about this matter and about you that you believe I should know.
Well, Your Honor, I wasn't going to say anything, but everybody in this court can see there's kind of a morbid obsession kind of thing going on here. And as my attorney said, we're trying to move on. I mean, there's so many lies made, you know, about my past. It's crazy. We're even trying to move out of state, but with this morbid obsession, it's keeping us here in this state. You know, we just want it done and gone. You know, that's about it.
Okay, thank you, Mr. Lang. When a court sentences an individual, I'm not sure where your 2017 conviction was. I don't believe it was here.
No,
it
was in Minnesota. It was in Minnesota.
Okay. At least in Wisconsin, when a judge sentences an individual, I have to look at 3 big factors and things. 1, the nature and the gravity of the offense. The second, I have to look at the defendant, your past criminal history, other things such as your age, your education, any needs for rehabilitation and services. And then third, I have to look at needing to protect the public. And although I can look at the public as a whole here, and I'm going to say simply because of your criminal history as a whole, but in particular, what I need to look at for protecting the public is MR. I forget her MR. And so that's where we look at with the public interest. Mr. Schmidt said it clearly that I am required to, by my higher courts, look at probation first. I have to look at probation unless I need to have you, or the community, the public needs to have you incarcerated to stop you from committing crimes and additional crimes. The second reason would be if cannot look at probation is if you need some type of treatment or rehabilitation that can only be met in an institution, in a prison, or in custody. The third thing is I wouldn't be able to put you on probation unless I must look at probation first, unless the crime unduly depreciates. Like if it unduly depreciates the crime, putting you on probation. And so I am directed from my higher courts that is the first thing that I must look at is probation and all of those other things unless something else falls into it. I understand, and I heard the victim's statement. It was very thorough. It was very thought out. It was very impactful. As I believe both attorneys have said, there are multiple things within that statement I cannot even take into account in my decision. If I do, overturned. There are multiple things in there I cannot use in deciding sentencing. Otherwise, I'm setting the court up for an appeal and to be reversed. I don't like that. And so I did take the heart of what MR stated, and in my knowledge, and I'm taking judicial notice of the 23 CV 102, that is the harassment injunction between you two. And so I do know some of the history between you two. You're both neighbors, both very close to each other with proximity. And that I believe at one time you were friendly, but then it turned. As both attorneys have stated, that with a case such as this, a harassment injunction violation, unless the behavior is so severe and so disturbing or violent, I have to look at probation first, because when I have to look at the incident and what happened, and here we're talking about fireworks being shot at the neighbor. Whether or not there are other incidents or other things that were captured on a camera, I don't know. I don't have that in front of me. The only way that I could have things like that in front of me is to come through the attorneys or to have them play it so I can visually see it myself. So all the facts that I have to go on are this one incident of the fireworks. So when you look at a case like this and you look at this matter and the violation of a harassment injunction, the underlying action here was not as serious as it could have been. But I do understand, I understand both of you right now. And I really hope, Mr. Lang, that you are meaningful and truthful in the fact that you say, I want her and her family to live in peace, and I want to live in peace. If I had the ability to build a wall that would separate both of your residences, I would do that. I would say a wall be built. You can't look in, you can't look out, you can't throw things over, you can't shoot fireworks, you can't do any of that. I can't do that. It's unfortunate that you both live in this same vicinity, and that it's not fair for either of you to have to move out. Otherwise, one of you would have by now if you weren't happy with where you live, your actual residence. So because of the facts of this case, I must look at probation first, because the facts of this case do not unduly depreciate the seriousness of the offense. But I do have to take the victim impact statement into account in my sentencing as much as the law will allow, and as much as I'm allowed to actually use with regards to the information that was provided. Because although I heard much about your criminal history from the victim, the law says I must follow the criminal history that's provided to me from the attorneys. I understand injunctions extremely well. Not only did I practice law with that area as an attorney, but I see injunctions and restraining orders all the time. They are very emotionally distressful. They cause turmoil. And sometimes it's just with one individual, sometimes it's with both. And they have a significant impact on a person. And as MR indicated, he wants to live in peace. And again, I'm hoping that that is something that you're going to be able to do. So in needing to protect the public, I have to craft a sentence to try and ensure that there's not going to be any violation and that the community, MR, and our family are protected. And so that is what I'm focusing on. And it will include, any decision and sentence here will include a no contact with victim, residents, and any family member that is there, and no contact through any third party, and that includes your wife. Rehabilitation is what the court is supposed to look at, and I can't, based upon the facts and what I've heard here today, I don't know if you've been rehabilitated from your past crimes. I don't know what you have done or what you haven't done. I don't know what your 2017 conviction in Minnesota was for. All I can do is sentence according to what I'm supposed to look at and how I'm supposed to protect in the ways that I can. With regards to the matter, probation is appropriate. But due to some of the things that I have said, and due to your criminal history, as Mr. Schmidt did state, that in this type of case, it is aggravated due to your criminal record. And it's unfortunate that I don't know any steps in rehabilitation or where you are. All I know is the facts that are in front of this court. So I'm going to give you an opportunity to show the world, to show MR, and to show yourself and your wife that you have the ability to live in peace and let your neighbors live in peace. But if you don't let them live in peace, and there are violations of your probation, violations of the restraining order, then you will be revoked off of probation, and your probation will be terminated, and you will be sent to jail to sit a sentence. And in a case like this, and in looking at all the facts, I'm going to give you the carrot of knowing that it's an imposed and stayed sentence, and have that hanging over your head of how important this is and how you must continue to abide by the parameters of the injunction. So what I'm going to do is I'm going to sentence you to 9 months of jail imposed and stayed. If you do all that you need to do, you stay on the straight and narrow, you don't need to worry about that. But if there's a violation, then you know that you will be revoked and you will sit 9 months of incarceration. That's a big incentive to live in peace. On probation, there will be absolute sobriety, no alcohol, no illegal drugs or substances. If you have a violation of sobriety, of absolute sobriety, you will sit 30 days of jail per violation. No good time, no Huber. That will be additional conditional jail and the violation, and you will go sit that in jail for each violation of absolute sobriety. And I'm going to warn you, with a violation of the restraining order injunction, if that occurs, because of the case and where it is in the facts of this case and what the charges are, most likely you're going to be revoked. Mr. Gramstrup.
He just asked me a question, Your Honor. It's something I can take care of later.
So it's very important that you toe the line. Hopefully, you said that you're looking at trying to move out of state. Hopefully, you're going to be able to do that and build a better life for yourself and for your wife. And then hopefully this can end. I'm going to tell you, one of the some of the worst cases that happen involve neighbors and neighbors disputes. And it can be extremely dangerous and extremely destructive. I've seen it. And that's the unfortunate thing. So hopefully everybody's going to be able to abide by this. So again, no contact with victim, residents, or any family member of the victim or anyone that resides in their home, and no third-party contact. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. The court is going to assess $443 in fines and fees. You can pay that at an amount of $50 a month to probation, not here, but to probation. I need to order your DNA. You need to go to the sheriff's department and provide that. This may be a case where you can have it expunged from the CODIS system, but your DNA is already in the system, but that's your call. If you fail to pay your fines and fees, not only will a civil judgment be entered against you, but you could sit up to 6 months in jail and a warrant will be issued. Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Gramstrup?
No, Your Honor.
All right. When you're done here, you must go to the jail, provide your DNA or see if they need that, and then go report immediately to probation and then get probation all set up. Is your address still on County Road Z?
Yes,
Telephone ends in 3506.
yes.
All right. Thank you. Then we are adjourned.
Your Honor, I got one thing I do want to say now.
We're back on the record.
So these violations are a year old, almost. And up until these violations came into play, there was calls, phone calls, accusations, lies, up until these violations were filed. But once the violations were filed, it's been crickets for a year because the so-called victim finally got what she's been setting up all this time. And I mean, this is a misdemeanor. I feel like I'm 40 years ago on trial for a murder. This is crazy, man.
I have to say a couple things. One, you said so-called victim. She's a victim. Second is I did take that into account. There have been no violations since this case was filed. And this case was filed in October of 2024. I did take that into account. If there were violations past that date from the filing date, you'd be in jail right now.
Exactly.
So there wasn't. And so that's why I'm hopeful that there's not going to be violations. You're going to build your life. You're going to be able to move out and then have peace.
I know. I got one more reason why there won't be any violations, because the parsonage that she lives in, she's being evicted because of
Well,
all the
that's not going
craziness.
on the record.
So amen to that.
All right. That's,
Amen.
please strike that from the record. Now, we have to reschedule Bedell because I think he has head count.
I was wondering about that when that cut out.
Yep.
Mr. Gramstrup?
Yes,
He'll need this for the DNA.
Deputy Krupa, can you make sure you walk them out? Thank you.
Oh, my dear Lord. When she says we're adjourned and he's like, I got one more thing. This thing was never going to end. Normally there would be no way I would make that into a video, but I got to be honest, now I'm kind of considering it just for the comedic value. But, you know, you get to about the hour 25 mark of her witness statement and people are going to tune out, and that doesn't do a whole lot for your YouTube stats. So I don't know what to do. I normally like Judge Mogan a lot, but that was exhausting. I don't know about you guys, but I don't, you know, Burnett County's so small. Apparently they had nothing else to do today except that. Bailey, wow, we made it. Yeah, somehow. So here's what I'm going to do. I had this queued up just in case. And I don't really need a just in case, but we need a change of pace. I can't recall what the original charge was. Says Ashley. Oh, that's so funny. And true. Oh, so true. All right, so anyways, I had this queued up. So yesterday we went to the Louisiana Pardon Board, 3 different times, I think? Yeah, I think 3 times. But there was another one that happened after the show was over. And I don't normally go back and play things from a previous day, but I wanted to play this one because it was different from what we normally see. So let's go ahead and take a look at this. Again, this is from 24 hours ago, so we're going to hop in the Wayback Machine. Michael already has his denied vote in, and I get that, Michael. But like I said, this one's going to hit a little bit different than what we normally see. My daughter and I, while we were sitting in the studio here doing some stuff yesterday, I introduced her to this, and we were watching them together often as we do here on the stream, making our votes and stuff, and this one kind of caught our attention. So let's give it a look, and we'll go from there.
Miss Holmes?
Miss Holmes is I would like to say that she completed anger management and parenting, and she hadn't had a right of disciplinary report since 2017. And that's about all I can really say about her. You have anything to say, Ms. Cootie? Definitely no discipline problems, agreeable for anything. Just due to her time, she's been limited to what she's been able to take.
Why is she limited? Why is she limited? Because we noted that she hadn't taken many classes.
What's your good time date, baby? 2030. Her good time date's not till 2030. And she can't have reentry until her last calendar year. She's not allowed to be in any other classes until 5 years. So
Okay.
Okay. Where she could be put in classes.
So she's taken all that she can take. Okay.
Anything she's been able to take, she has taken.
Okay.
She's always tried.
Okay. Appreciate it. Okay. Today we're here for the parole hearing on Ms. Holmes. We also have here today that will be speaking on Ms. Holmes's behalf, Andrew Hundley. The Parole Project, Hannah Rose. I'm not gonna try to say your last name. I'm gonna just call you Miss Rose. If that's okay with you, Miss Rose.
Yes, that's
Okay, attorney, Kamari Holmes, his son, Shan Holmes' brother, are all here at headquarters. They'll be speaking, not speaking but in support is Leanne Jocko. Louisiana Parole Project, and Christy Cherami, Louisiana Parole Project. And then speaking in opposition will be Delta Scott, victim's sister, Donald Smith, victim's stepfather, but he will not be speaking, but he is here. And Wanda Smith, victim's mother, who will also be speaking. Okay, and we will call on y'all at the proper time. Okay, Ms. Holmes, tell me, what did you do to get yourself in the prison? And why do you think you're ready for release today?
First, I would like to begin by saying I am deeply sorry for the pain, the suffering, and the loss I caused. I caused the Scott family. I would like to say I deeply apologize for reopening these wounds today. But 20 years ago, I made a terrible decision by taking the by taking the life of Mr. Scott. Mr. Scott was someone I just met that night. And I picked up a knife and I took his life. I can't say how deeply I'm sorry for the pain I have caused the family. I know that the Scott family have to live with this pain and loss that I have caused them. I know there's no words that can express how deeply I'm sorry.
Okay, can you try and tell us why do you think you're ready to get out at this point in time?
I'm asking this board to please grant me parole because I have taken every opportunity that I can to rehabilitate myself by doing classes. I went from literacy to GED to Ashton University, where I received my associate's degree. I'm currently enrolled to get my bachelor's degree. I believe that I have got the tools to re-enter society. I'm very positive that I can be a positive role model in society through the parole project program. I can continue my rehabilitation on the outside with them. They have counseling. They have AA and A meetings that I can attend. My goal is to re-enter society and be a great role model for those that has been through similar situations as I have, And I believe that I'm positive and confident to say that nothing like this will ever happen again. I would like to take the time out to say I apologize again to the Scott family for the loss and the pain that I have caused them. But I know today, the person I am today, that I can re-enter society and be a positive impact.
Thank you. We appreciate that. Let's hear from the people here to speak on your behalf. Mr. Andrew Hunley.
Good morning, Andrew Hunley with Louisiana Parole Project, appearing before the board to confirm that Ms. Holmes is a client of our organization, and if she is to be granted parole release, we're prepared to take her into our comprehensive reentry program. Like to first start off by saying that we, had done considerable amount of due diligence in reviewing Ms. Holmes' record, both her criminal record, what she's done during her time in prison. Would like to echo that it's our opinion that she has done as much programming as she could possibly do under the circumstances. We believe that she needs continued programming if she is released, but because of the facility where she's housed, she's done everything that she could do. We're very happy with her disciplinary record, and she's shown an ability to be able to function within rules, and we're confident that if she's given early release, that she would be able to function within the rules of society under our mentorship, and have a strong foundation. So a few things. First and foremost, we would ask the board that Ms. Holmes be required to spend a minimum of a year with us, and because she needs significant reentry support, considering how much time she's been incarcerated. So we would ask that she be allowed to stay with us for 1 year, and then we would reevaluate her continued needs at that 1 year point. Second, we would ask that the board make it a condition that she be required to continue her education. She obviously has been very successful, going from getting her GED, then associate's degree. We think if she continues her education, it would benefit her long-term success, and we would be ready as an organization to ensure that she would get enrolled in continuing education and reach her next degree. And then finally, our staff social worker has presented a behavioral health plan that we would like her to follow. So we would ask the board mandate that she follow all behavioral health recommendations by Parole Project social work staff if she would be released. But if she would come out, she would have access to every resource our organization offers. We do see her as a long-term client, and someone who would have access to our employment program. We'd work to find her a job after she completed the first month of programming in our organization. And then she would have access to staff mentors, as I've stated before, the social work staff. We do believe that she is ready for a second chance, and after 20 years of incarceration, she's shown that she has a considerable amount of remorse and has considered changes to her life to ensure that she doesn't find herself in the same situation she did 20 years ago. But as an organization, we're ready to give her the wraparound support she would need to be successful. And I stand by to answer any other questions you may have about her reentry. Thank you.
Thank you, Mr. Hunley. Ms. Rose, I'm gonna leave it up to y'all to see who wants to go next. And please state your name and relationship to the offender.
Good morning, y'all. My name is Amari Holmes, and
I'm there speaking on my mother. Words really can't explain how I feel about my mother. Have no memories, really. I have no photos of my mother at all. I haven't given transparent on love physically, but she always found a way to stay contact with me, make promises that we're still holding on to. As long as I still have in trouble, she would. And that promise been made for about 15 years now. And say that they're in the middle of my life, I feel like I'm trying to play fine. But like, she, I can't say how she was before. I don't have it either. But from my point of view, she's a great woman. And as a mother, she always did what she can to keep me on track, even if it was just a phone call. Mother, I believe she's the most woman. She always tried, even though she was faith. I knew she feels bad from leaving or from the mistake that she did make. I like from not be here and to be with her. I love my mother more than she knows. Even though there's a lot of things that she don't know about me, and me as well don't know a lot of things about my mother. But I really feel curious, and I know she's very good experience. Each other love and grow together.
Thank you. Thanks a lot, Mr. Holmes. Ms. Shan Holmes? John, or Mr. Sean? Brother?
Sean Holmes.
Speak up a little bit, please, sir.
Hello, Kiana Holmes' brother, Sean Holmes. I would like to first and foremost apologize to the family. Of course, the situation. I am Kiana Holmes' brother. In 46 years. 46 years. To the roll board, I, Sean Holmes, Miss Kiana Holmes' brother, like to ask you at this hearing to be at good order. And minded for the release or granted parole for Kiana to be able to come home and tend to her loved ones, also children, that she hasn't touched or even practiced smiling when she's happy since the last time that we have physically have been in her presence. I know the changes that a person has gone through to make a difference for themselves, also family, while being incarcerated. It does take time to make a difference when there's no one that understands you completely, but the difference we make for ourselves. Show the ones that doesn't understand that change is a part of growth and also prosperity. I think that Kiana has grown over the years more than I can really imagine since we were kids playing in the backyard. She has achieved her high school diploma or GED and also her associate's degree. And for that being said, I am very proud of her. Also, the simple fact that the judicial system has given her the opportunity to achieve these goals for herself within her lifespan. I really can't wait to see her again at home with her children, looking and feeling successful like she is, knowing some people did not have that opportunity. But God has given her a second chance, and I know she would have all the love and support from her entire family because we listen and love her. And also understand that change when the opportunity is at hand. And if you take that chance, you're proving to everyone else that you're willing to take that risk while others thinking it is impossible. And once you achieve that, you're fighting for, they finally realize that you're a person of good choices and character. So if you can change your if you can change your peers' ways of thinking of you, you can change the way the world think of themselves. I wish unto the court that you release my sister from prison so the world can see that it doesn't take just the judicial system to change the way we think of each other. It takes making the first step, what she has done, to change yourself so God can make a better path for you to be able to prosper through and beyond. Thank you. So, I apologize.
Thank you. Okay, Ms. Rose, I guess it's Rodell?
Yes.
I did, okay, Ms. Rodell?
Yes, hi, my name is Hannah Rose Rodell. I'm an attorney with Louisiana Parole Project, and I represent Ms. Piano. I want to begin by expressing, on behalf of Ms. Holmes, a deep and sorrowful remorse to the Scott family for the unimaginable loss they have suffered. There is no sentence, no amount of time, and no words that can ever bring back their son, their father, their brother, and loved one. Ms. Holmes lives every day with the knowledge and weight of that loss, and she carries a profound sense of responsibility and regret for the harm she caused. Today, however, the question before this board is not whether harm occurred. It unquestionably did. The question is whether Ms. Holmes has demonstrated the rehabilitation and transformation necessary to safely re-enter society. I am here to tell you that the answer to that question is yes. Kiana Holmes, you are meeting today, is humble, intelligent, thoughtful, and genuinely remorseful. She has taken responsibility for her actions, not just by pleading guilty 2 decades ago, but also by committing herself to meaningful, long-term change. Her transformation is rooted in sustained effort over time, deep introspection, and a commitment to living a different life. Self, for her children, and now for her grandchildren. When Ms. Holmes entered prison at 25 years old, she was a traumatized young woman, broken not only by what she had done, but by the layers of abuse and pain that had shaped her life since early childhood. While the full scope of that trauma is outlined in the materials submitted to you, I won't dwell on it today. Instead, I want to focus on what Ms. Holmes has done in the years since, how she has grown, how she has taken accountability, and how she has prepared herself for a safe and productive life outside prison. Like many who come into the system of young people, Ms. Holmes struggled at first. She did not give up. Through her Christian faith, her enduring commitment to her children, and a powerful dedication to educating herself, Ms. Holmes has evolved. She has become the first in her family to earn a college degree. She has completed every program available to her. She has maintained meaningful, loving, and supportive relationships with her family and mentored her peers along the way. Other incarcerated women at the Louisiana Transitional Center have written letters describing her kindness, humility, and leadership. One woman wrote, "She hasn't spent one day here just laying around. She is in college, she has completed classes, she takes part in church activities and Bible studies, and can always be found with a book, further expanding her knowledge." Another woman wrote, "Kiana is one of the most level-headed people I've ever met. She is one of those rare people who come across in here that will go back into society with zero chances of returning to prison." Even correctional staff have commended her as someone who uplifts others, volunteers first, and brings peace to the prison community. To quote one of the staff members, "She always has a smile on her face, and when volunteers are needed, she's always at the front of the line." Ms. Holmes comes to you today as a mature, self-aware, purpose-driven woman, a woman embraced by a strong community of support. As you heard, the Parole Project has committed to her long-term reentry and will envelop her with counseling, education, programming, mentorship, personal case management, housing, employment assistance, and more. Additionally, Ms. Holmes is prepared to embrace whatever conditions or stipulations Ms. Holmes sees fit. Ms. Holmes is surrounded by a loving family, some of whom we've heard from today, and others who have written letters in support for you. Her daughter, Kashawn, writes, I want to thank my mother for her constant support and belief in me. Her words of encouragement inspire me to be humble, work hard, and achieve what seems to be impossible. Not a day goes by when I don't think about her. Ms. Holmes' adult children who have lived nearly their entire lives without her choose to remain close to her. And while Ms. Holmes is grateful for that connection, something Mr. Scott's family can never have with him, she knows she can and must do more, and she is ready. This is not a person with a pattern of criminal behavior. Ms. Holmes is a first-time felony offender, someone who in a high-stress moment of fear and desperation made a life-altering and tragic decision. And for the past 20 years, she has made every effort to understand that moment, take responsibility for it, and do what she could to ensure nothing like it ever happens again. In the months I've worked with Ms. Holmes, I've seen firsthand the depth of her commitment to personal growth. I have been inspired by her empathy, her self-insight, and her dedication to her family. She knows that release is not the end of rehabilitation, but a new chapter. As she said to me, I am still working on myself every single day. Ms. Holmes is not asking to undo the past. She is asking for the opportunity to build a future that honors the lessons she has learned and the life that was lost. For these reasons, and the reasons set out more fully in her memo, we respectfully ask this board to grant her parole based on the growth she has demonstrated, the woman she has become, and the readiness she shows to contribute meaningfully and safely to society. Thank you.
Thank you. Okay, now we're gonna hear those who have come in opposition. Do y'all have any preference on who's gonna speak first? Which one of y'all want to speak first?
Delta, I'm Freddie's older sister. Live in Houston, but I forgive her. I forgive her. And I think she is ready for change. At first I came in with another mindset, but Freddie, we lost our other brother last year. They was like 11 months apart. It was so, he never recovered from Freddie dying. So that was kind of eating me up inside. But seeing her today, listening to her, I think she need to be on with her kids. Give her a second chance.
That's very, very,
Yeah, thank you.
very honorable of you. I appreciate it.
Yeah.
Okay, and Miss Wanda Smith.
Forgive this one. But I miss my child and I love her and very appreciate. You know what you do. You know, and the only wish she would have just told me if he did anything to him, could have come for me, I would stop it. But she did, so I still love my child and I hope we're close for a long, long time. Still is. I'm taking heart medicine for it. You know, my child, Freddie was 26 years old. And we did everything together. I love him. I love them all, seven of my children. I love them all. And I still do. Go out there and see him. I know he can't talk. But you know, we just know, I know she's young, and you know, we all make mistakes, I guess. You know, but I would never try to hurt nobody because you wouldn't raise up like that. You didn't do the things that the young girls do today, you know. I was young too, now I'm older. And I still won't do it. And everybody from my child Freddie, he loved with everybody. He'd be friends with everybody. Everybody. He was friends with everybody. He ain't got no money. He just gonna go up there and be friends with you. He was a peaceful boy. But like I said, I forgive her, and you know, it's hard pill to swallow, but you know, I know she's still young, you know, still young. So, well, I go ahead and give her a second chance. You know, she'll be all right. You know, I know I can't get crazy my son back. But I know what God needs one day. Thank God, man.
Thank you very, very much
Okay.
for both of y'all coming today. Okay, your case has been assigned to me, Ms. Holmes. You know, most of the questions that I was gonna ask were brought up by your attorney and Mr. Hundley in their plan. The one thing I am a little concerned about, tell me about this this incident with this other inmate back in 2016. What was that about?
I was on the yard and they had two offenders arguing with a friend of mine, and the officer sent one of them in, and I was still out there and I was trying to diffuse the situation. So when I went up to talk to one of the offenders, another girl hit me. And I was defending myself and it started a physical altercation.
Okay. And
during the physical altercation, CO officer Miss Holtz walked up, and out of my peripheral vision, I saw that inmate Sarah was about to hit Officer Holtz, so I pushed her out the way. I was trying to protect her, but I made a huge mistake by doing it. But I have learned by changing my environment, the people I was around, that I started reading, I started going to church more, I started doing everything to make sure that
I just want to know what it led up to the incident. Okay. And it's quite obvious you still have contact with your children. I was asked about that. Really, after hearing from the victims and everyone that is presented, I have no further questions. Okay, is the panel ready to vote? Okay, since it was my case, I'm gonna vote for first. Ms. Holmes, first off, you've done a very good job while you've been in jail. You have taken you know, all opportunities that were given to you. You've reached out and tried to do them. I do not think you're a threat to society, and with no opposition from the victims, my vote today is going to be to grant to the parole project, and you are to stay there a minimum of 1 year, okay? I want you to stay there at least a year. Take some anger management classes. I still want you to work on that. You got to make sure we keep our temper in shape. But that is my vote today. Oh, and no contact whatsoever with the victim unless initiated by the victim.
yes, sir.
My vote is also to grant parole to the parole project for a period of 1 year with an emphasis on following any recommendations after a mental health evaluation. So if you need any stabilizing medication that you are on those. And good luck. And I do want to say on the record that I'm very impressed with the Scott family and their willingness to demonstrate their support.
Byron?
Yeah, I'm gonna go ahead and vote to conditionally grant your parole. And my decision was heavily weighed on the forgiveness of the Scott family. Also, I'm also gonna order that you stay at the parole project for 2 years and follow all recommendations for treatment, including the behavioral health program with Excel that you've already started, that you complete anger management on the outside, just a refresher again, and outpatient substance abuse, that you submit to random drug screens, and as Pete said, no contact with the victims unless they ask for it. And that you continue your education. And good luck to you.
Okay, thanks, thank y'all, and your parole has been granted. Good luck to you, ma'am. Thank you, everybody that participated.
So there you go, my friends. I told you I wanted to show you that for a reason. They don't necessarily work out that way all the time, do they? I think you've heard me say before that it's hard. It's a hard life if you're going to live with hate in your heart. And obviously this family seemed to, at some point, hopefully sooner rather than later, they figured that out and they found it within themselves to forgive her. Now it's there's two sides to that. Just their forgiveness alone, I don't think would have been enough for her to be granted her parole. I think that she also needed to put in the work, and it looked like she did. And those two things came together in the end. And was justice done right there? I think it was, because she paid a hefty price. She lost 20 years of her life, which, that's a quarter of it gone. So that's no small thing. And she spent 20 years having to work on herself. But she paid a price that the family felt was good enough, and they forgave her, and I think it was all good. So I wanted to top the day off with that, especially after having to suffer through Burnett County and all of that. But it's good to have a win every now and then. And this, again, is why I go to these kind of off the beaten path things, is that it brings us stuff we don't always see, and sometimes it's really good. And I think this was really good. So I don't know about all of you, but I'm going to be cheering for her. And I hope that she's able to, with what she has left of her life, able to live it well and contribute to society and to her family, and things will be good. All right, guys, let's leave it there for today. Thank you so much, as always. I hope you enjoyed it. I know I did. You guys are the reason why I get up at dark 30 every day, and I just want you to know that. But we'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. If you're not a channel member, again, go to the pinned chat. There's a link there. I encourage you to join us. You'll like it. It's fun, and it's not expensive. So please do join us. Become a channel member. Go have yourselves a great Thursday. Enjoy your day, and I look forward to seeing you all tomorrow. Take care. God bless.